With the leave of Honorable Justice Mr. Ritobroto.
Leave to mention a matter, my lord, for inclusion, my lord.
Appeal?
Appeal, my lord. Original side.
Original side?
Yes, my lord.
Which year appeal?
My lord, appeal of 22, my lord. The order impugned is of
It
June
is
20.
assigned to us.
My lord, this is before your lordship, my lord.
22 appeal, sir, wait for some time. We have taken many mentioning. Try your luck after 2 weeks. Come and tell us we shall.
I'll come back after 2 weeks, my lord.
Yes.
My lord, kindly recall, my lord, Friday I mentioned the matter that yet to be filed at that point of time on the grounds, my lord, 72 hours.
filed?
I have filed, my lord, the number has been given. But tomorrow let it be appeared, my lord, application.
Did you file it?
My lord, on
Friday.
Friday. And the service has been completed.
Friday you filed it?
Yes.
Kartik. Yes.
Much over.
Lord, leave to file blood with the server copy. Order was passed on 17th of this month, and blood today I am seeking the leave. Urgency is this, blood. I being the
Certified copy you applied?
I applied for, but not
70. What is the urgency?
blood. Yes, blood. I being the plaintiff, file a title suit before the court below against the private respondent for cancellation of the particular deed. There is an order of injunction over the property. There is a blood the tenant who is the Bongio Gramin Vikas Bank. The defendant of that suit approached before the tenant for recovery of.
What is the urgency?
Blood, the trial court has disposed of giving liberty to the defendant of that suit to collect all the rent, area rent from the bank during pendency of the suit.
9 appeal how?
My lord,
Group 9 appeal.
Group 9, lord.
It's a civil suit.
Civil suit, blood. The suit was filed by my client against.
What is the order?
Order was passed passed in a writ petition. A writ petition was filed by the present respondent seeking blood for leave to collect all the area rent from the existing tenant during pendency of that suit. And the trial court, Lanet.
Are sir, why did they come to High Court?
The representation was submitted before the bank for collecting of all the area rent during pendency of the suit and the order of injunction. That representation was not considered. Writ petition was filed. The honorable single judge has disposed of the writ petition, granting leave to the defendant, who is the private respondent here, to approach before the bank for recovery of all the rent during pendency of the suit and order of injunction.
So very good. What is the urgency then?
But
what is the urgency?
Urgency is this.
File it in 48 hours notice, it will appear. Yes.
Blood leave. Just I seek the leave to file the blood without.
Don't find any urgency, sir.
Blood. If
no urgency.
If the rent was collected,
order has been served.
Yes, sir. That has been served, Lord.
We don't find any urgency, sir.
Lord, they kindly consider otherwise that if the rent was disbursed by the bank in favor of the private respondent, my appeal will become infectious.
The rent has been deposited in the bank.
Bank is the tenant over the property.
Right. You are for the?
I am for the plaintiff in the suit. The
landlord.
The bank was inducted as a tenant under me.
Very good.
The sale deed was procured by the defendant, who is the private respondent before your lordship.
We don't find any urgency, sir.
But if the rent was, kindly see the last portion of
the order.
Last portion, Lord, this certain time was given to approach before the bank.
There is no legal impediment to do so.
But this title deed is this.
No urgency. Yes. Yes.
May I mention one matter for inclusion in the list?
Pardon?
Inclusion in the list.
Are you mentioning about notice?
Yes, Lordship.
Application.
Appeal.
Which year appeal?
2024.
24. Madam, wait for some time. 24 appeal, residuary appeal. নিয়ে নাও তারপর দেখো requisition করো. Yes.
Grateful,
Yes, sir.
With Milord's kind leave, Milord, on last week, Milord, heard the matter at length, Milord. This matter relates to illegal filling of water body, Milord, where a matter is pending before the NGT, Milord. Your Lordships were pleased to fix the matter on 26th at 3 p.m., Milord. Now, what has happened is that, Milord, from media reports, there are evidence galore, Milord. The promoters, the respondents, are filling up the pond in a rocket speed, Milord, with using all heavy machinery, even using making arrangement for light at the night, Milord. They're using light, all kind of infrastructure to fill up the pond on a fast.
My lord, I am appearing for the respondent in the matter, my lord. The
We are
matter
in
was
scene
heard.
of the matter. We are in scene of the matter.
Yes, my lord.
On your prayer, the matter has been fixed at Wednesday.
No, my lord, the matter, we had requested the matter, we had agreed to fix the matter today for hearing. My learned,
No.
yes, my lord, my learned senior friend had a problem,
My
so
lord,
the matter was
Very
fixed
good.
on Thursday, my lord.
Very
also
good.
taking.
So
Lord,
you will
I-
go on. We are hearing the matter.
But are you filling up the pond?
Lord, the work,
Why?
the work,
We are hearing the matter, you're filling up the pond.
my lord, there's no, I'll take instructions,
there
I do
is
not
no
have
say.
instructions, I'll
My
take
lord,
instructions
media
in the
reports.
matter. My lord, let me come back at 2 p.m. Mr. Bag was just here, my lord. Matter was called.
Lord, maybe.
Let me
Matter
come back at
not at your beck and call, sir. We are in scene of the matter. Who gave you the permission to go on with the construction? Huh? We'll appropriately deal with you.
the matter is fixed on Thursday, my lord.
Forget about fixation. Who is your president or chairman of your company? This in what was the name?
Unreported Buildcon is a
Unreported
private
Buildcon.
response, a company.
Who
18
is
companies.
who is the person concerned? Head of the matter, say, state of affairs? Who is he?
My lord, the directors are there, my lord.
So we will call the directors. Matter agreed on terms. We heard it. We kept it as for orders Wednesday. You are going up
On
with the
Thursday,
construction?
on Thursday, my lord. The matter has been fixed on Thursday at 3 p.m., my lord.
So very good. Thursday, you are going on with the construction. Call Mr. Bag at 1 o'clock. And if you fail to appear, we will summon all your directors in court.
Mr. Bag
You
will
better be careful.
My lord, Mr. Bag will be here at 1 p.m., my lord.
There is no stay, my lord. We will can go on, huh? Mr. Bag said that, yes, we said that you take instruction.
We'll be here at 1 p.m.
Come here, ask your counsel to be here, ask your counsel to be here at 1
Grateful, my
o'clock.
lord. Grateful.
And if you do not appear, your directors would be called.
No, my lord. We'll appear at
Yes.
Grateful.
My lord, contempt application will include.
Contempt of our order.
My lord, your lordship sitting with Justice Venumali, my lord.
Hmm?
Your lordship sitting with Justice Venumali, my lord.
Velum. Yes. Yes, any further mentioning from our list?
Yes, my lords.
On urgent.
With my lord's permission, with my lord's, my lord.
Wait, madam.
Not yet
Just a moment.
completed,
Just
not
a
yet completed.
But one urgent application, my lord, before vacation, I wanted to file it without the certified copy. Your lordship asked me, you opted for certified copy, and then because the learned Singh judge is proceeding with the
got
contempt.
it.
Yes, my lord, I have filed with the certified copy. The contempt application is fixed on, my lord, next Friday.
From notice. Have you given notice?
No, my lord, I shall serve notice today, my lord, itself.
No, that is not the system we follow.
Very well. My lord, after serving notice, my lord, today, my lord, tomorrow I shall mention it, my lord.
When will you get? Tomorrow is not the mentioning day.
My lord, Friday is the fix the contempt application for compliance, my lord. Question of fraud is the read petition or by sub
So you
fake
should have
documents.
given a notice, Mr. Badi. We feel embarrassed this way. We refuse advocates from mentioning since there is no notice. Give a notice, mention tomorrow. Yes.
It is 2023 lottery prize winning matter.
Pardon?
Lottery prize winning matter 2023 for application.
Use the microphone, please.
Please use the mic.
Use the mic, please.
It is the matter of 2023 lottery prize winning matter.
So it's an appeal hearing, final hearing, or an application?
An application.
Application. Are you mentioning upon notice?
My lord, it is old matter 2023 filing.
So old, that is why no notice required. Give a notice and come back on Thursday. Yes, what do you mean?
My lord, with the leave of Honorable Justice Ritobrata Kumar Mitra, I am being led by Miss Masuri Swaraj in online, my lord. OBC matter, my lord, contempt application.
Yes, madam.
My lords, with my Lord Justice Mitra's permission, I would like to mention a matter before Honorable Justice Chakraborty. My Lord, on 17th of June, my Lords had actually stayed 5 notifications in the OBC matter. Very strangely, the state, in violation of my Lord's order, is still continuing the recruitment process as per OBC A and B category. My Lords, we have filed a contempt petition. I am seeking my Lord's indulgence to have an early listing of the same.
Contempt, they will if they take consequential steps, then in contempt they will. We have fixed the matter, madam. On 24th, we have made it returnable, na?
My Lord made it returnable in July, but my Lord, what they have done is 71,000 applications have been received as of 18th of June. The whole subterfuge here, my Lord, is to ensure that so many people apply that in case if my Lord's decision is not in favor, then they will create an irreparable situation, an irreversible situation. In fact, what fell from my Lord's earlier was also that we file a contempt and mention, which is what fell from my Lord. We are doing that. We have filed a contempt. Now we are seeking listing of the same.
No, if the follow-up steps still they take, that will be subject to the contempt. What is the urgency? We cannot stop admission now. If they do so,
List will be published on 1st of July.
where from you come to know?
The online statement of the minister itself. List, merit list. Before that, any day, my lord. Any day, my lord. It will just.
This way it cannot be listed. This way you cannot be listed. You
Ne-
come and you give. Where is your notice to the other side?
My lord, it is a contempt application. My lord, contempt, my lord, we generally don't serve notice.
Contempt application.
Contempt application.
Very good.
My lord, it's with a filing number, CPN
Where is
number.
your contempt application.
It is already filed. We are having a filing number, CPN number. My lord, today we will receive.
So have you stated in your contempt that tomorrow is the date fixed for listing the for publishing the list?
My lord, yesterday, my lord, we came to know that the list, merit list would be.
এটা শোনো তুমি ওই মানতে কোর্ট অফিসার কি come back tomorrow and mention.
My lord, I'm giving this one.
No.
With my lord's kind leave, my lord, I'm mentioning upon notice.
Mentioning over. Yes, call the list.
Your Lordship, I'm for the appellant. I'm praying for not today, Your Lordship.
But I appear for the state respondent.
I'm happy for the respondent / state petitioner, my lord.
Nothing matter. What are the applications about?
Your Lordship, Ernest Senior for this case.
Why do you file matters, madam? Why do you give the
It's a
returnable?
humble request, Your Lordship. He is not will that this is the thing. He's
Adjournment,
suffering for high fever, Your Lordship.
First thing in the morning, adjournment. What has happened to your counsel?
He's in high fever. He have high fever, Your Lordship. That's why
He's on record.
Tirthankar Basu.
But they do not bother to appear. Person who is this was the practice which was there.
It's a humble
Nowadays
request.
that practice has gone.
I understand, Your
They
Lordship.
are least bothered about the court. Your advocate on record is not there. You do not know ABCD of the matter. You come and say fever, suffering from fever.
Humble
Please,
request.
please, this practice should be undone. Who is your advocate on record? So
Tirthankar
he's
Basu.
so busy that he cannot appear before us. Must be sitting in any of one of the rooms, and you are saying he's before a court. Which court he is there?
He's not in any.
So where is he?
He's suffering from high fever, Your Lordship. That's why that I said, Your Lordship. Understand, Devashish Chattopadhyay is there.
Then who is your senior counsel?
Devashish Chattopadhyay.
Where is he?
He's suffering from high fever, Your Lordship.
Both of them are suffering from.
Basu?
Tirthankar Basu is the advocate on record, but
Where is he? Is he in court?
I don't know, Your Lordship. Ernest Senior will do this matter actually, Your Lordship. It's a humble request. Kindly fixed it to yesterday. Tomorrow he will come. Kindly. It's a humble request, Your Lordship.
Next week.
Grateful, Your Lordship.
The viral time has come. The viral fever is very infectious nowadays. That's a good ground.
Who is into? You're there.
The respondent from the last week, on my ground, adjournment was sought for. I had an eye operation. The Kishore Datta was appearing for work.
You agree to a date with them because adjournment. We are fed up with this. You agree to a date, come and tell us when both of you.
Only one thing, there are 2 other appeals have been filed. In fact, there are 15 writ petitions. 15 writ petitions were filed by the directors, my lord. The leading directors, my lord, they alleged, my lord, atrocities as the instance of a federations, my lord. The federations of 20 trade unions, my lord, controlled by influential persons.
Trade union?
Of Tolly industry. This matters pertain to Tolly industry.
I see.
The Federation of Senior Workers Associations, they are the.
You are the writ petitioners.
I am the writ petitioner.
I am also, my lord.
And he is also, my lord, appearing for one of the writ petitioners. Well, there are 15 writ petitions. Out of that, in 3 writ petitions, my lord, the appeals have been filed. One is appearing. The other 2 are not yet appeared.
My lord, so far as the appeals from my writ petitions, my lord, which have been filed, my lord, those are not appearing, my lord, before your lordship today. My learned senior friend, my lord, has filed.
State's appeals against 2 orders passed in our writ petition. Well, all the 3 appeals may be.
Your writ petition means you are the.
Mr. Mojumdar is leading me.
Oh, achha.
Well, we are for the writ petitioners.
Now, who is the appellant?
Appellant is state.
Mr. Datta is.
State has preferred 3 appeals against 3 orders passed in 3 writ petitions.
Very good.
So, my lord, same order.
Same matter.
Identical matter.
So those are not here.
Those are not on board today. But the matter is extremely urgent, my lord.
But I'm told, my lord, the other matters were mentioned on Friday. Acha. My lords were pleased to, my lord, observe that.
Friday we don't have any mentioning, first of all. I don't know whether she mentioned.
কবে করেছো? মেনশন করেছিল ফ্রাইডে? ফ্রাইডে?
ও তুমি ফেডারেশন না?
ও আচ্ছা।
Friday mention করেছো? আমার তো ওনাকে you mentioned, madam. You were there on Friday or you are missing the date?
Matter was returnable on Friday, your lordship.
Returnable. Those 2 appeals were returnable on Friday, your lordship.
Returnable is one thing. You are saying, your senior is saying that you mentioned before us on Friday.
Yes, your lordship, I mentioned on Friday.
Last Friday?
Yes.
দুদিন আগে?
Stop করা দে তো।
How many appeals?
3 appeals.
He's saying there are 15 matters?
No, from my side there are 3.
There are 3 appeals, my lord.
15 writ petitions, 15 orders, they preferred 3 appeals.
3 appeals.
Oh, achha.
Against, in respect of.
So there is no chance of filing any further appeal?
No, I have no idea.
That may be a continuous process on the part of the state, my lord. We are not concerned right now.
This is an interim.
এই তো কি চাই?
All right, Mr. Datta, ask your junior to give the
এই নম্বরগুলো দিয়ে দাও, অন্য দুটো। আর তোদের কোনো অ্যাপিল নেই তো?
না।
অবশ্যই তোরা তো।
Well, your lordship may post these matters this week, my lord. It's urgent, my lord. Extremely urgent.
No, we are keeping it next month, Mr. Mojumdar. We are in June, Mr. Vasu. Yes, give the.
এই নম্বরগুলো একটু দিয়ে দেন।
Easy.
It's for the federation.
Why you are here?
Associates Federation.
ছেড়ে দাও, খালি ওইটাই ছেড়ে।
Wednesday.
Wednesday.
Wednesday কিছু আছে? Mr. Datta, Wednesday you will be there.
Online, everything online.
Wednesday কিছু ফিক্স আছে নাকি উপরের দিকে?
8580 তো বলছি।
কি করে বুঝবে বলো?
8580 লিখেছিস? 857 আর 858
ঠিক আছে। All the other appeals will also be there.
Great.
Yes.
I'm grateful.
বুধবার পরশু
Serial number 3, 4, 5, and 6.
Yeah.
This is in regard to 6. Since I am arguing 6, and all the document has been filed in the 6, all are the identical matters. On previous occasion, this matter has came up for consideration.
You filed supplementary evidence.
I have already filed supplementary affidavit with a copy to my learned friend.
Who is opposing
Mr. Chakraborty is there, and many persons are there. Mr. Chakraborty, Tanoy Chakraborty is there. On that day, he entered appearance before this court. And Milord, this matter has been fixed on 19th, and subsequently, Milord, 19th, this matter, Milord, has not been listed, and due to Milord, the business of this court, Milord, and subsequently, Milord, today the matter has been listed. Pure questions of law, only an interpretation of a clauses of a contract. On previous occasion, I have started argument.
There is no interim application. Is there any interim application?
No, Milord, there is no only application for appropriate order, because on application, without there being any application, Milord, NAT would not be filed, and that's why, but no stay is required.
Mr. Dotto, file a paper.
What point is involved? Nothing is there, Milord. Only, Milord, my my application for
Nothing is there, and you filed a supplementary affidavit. So we don't know how many of these more will come. Becomes very difficult. Once you file the paper book, Mr. Dotto, it becomes more comprehensive.
We direct you to file the paper. Writ petition was on affidavits.
No. Only for an interpretation of a clauses of a contract.
We understand, but there is a supplementary affidavit. They did not.
Well, I will do that. I will do.
No.
They might want to file an affidavit. State might want to
We
file
don't know whether they want to file any affidavit to this. Otherwise, we could have directed.
In the trial court, Milord, they has not prayed for any, Milord, for filing any affidavit in opposition, because this is only for an interpretation of a clauses of a contract, Milord. If your Lordship, Milord, permits me, I can place it. I am seeking for a remand, a demand of a certain sum.
This Tanoy Chakraborty.
They are badly busy, I think.
He didn't appear on the last occasion also.
Yes, Mr. Chakraborty entered appearance. Kindly see the order. He appeared. One order has been passed.
Order dated 1st May, he was not there.
The later compilation.
I know, my lord. He entered appearance on that day.
No, we believe you, but I'm saying he wasn't there on the last occasion.
Have you
in one matter, Mr. Galib is there. In one matter, Mr. Ganguly is there.
No. Have you complied with this order of 10th March?
You are asked to file a compilation.
He is coming. Only his understanding is, my lord, 4 appeal has been preferred. Yes, I know.
You have been asked to file a compilation. See the order.
Lord, I know. That has been clarified on previous occasion. There are 4 appeals. In regard to number, my lord, the serial number 6, we have filed a exhaustive document. So since that would be bulky, that's why in other 3 matters, all those documents has not been filed. So therefore, I have requested the court officer, Lord, so that the Lord serial number 6 would be placed to your lordship, where all the documents has already been given. That's why.
Serious number 6 may be served to us. It has not been served. I had requested on the previous occasion
So,
also.
Mr. Chair, do you want to use any opposition to the application? Otherwise, we direct.
It's a point of law, my lord. It's a point.
So then we direct filing of paper book.
Yes, my lord. But
so there will be one paper book. We will be hearing 4 appeals on the basis of this. And
Documents are same.
Milo. Same.
The same contract in which.
Same contract.
And same order or 4 different orders?
Yes, yes. Same order.
Oh, all the 4
Yes,
arising
yes.
out
It
of
was
the
heard
same.
analogously. It was disposed of
It
analogously.
is a ILA project for different reaches, same contract, everything is.
Terms are the same. Not the same contract. Dates are different, possibly the contract.
তাহলে তো দেওয়ার দরকার পেপার বুকই দিয়ে দেবো তুমি
দিয়ে দাও
All the paper books will be heard on the basis of the same.
কন্ট্রাক্ট গুলো আবার ডেট গুলো আলাদা কিন্তু কন্ট্রাক্ট
এসে যাবে না
হ্যাঁ টার্মস তো এক
Supplementary
in regard to 6 because all the
Mr.
documents.
Chakraborty, which matter are you appearing in?
4 and 5. I'm appearing for all the matters, but 6 I have not been served. I'm all appearing for the.
Yes,
I had argued
I
this
give
matter.
the paper book itself, so there is no.
Yes. Parties are represented. Parties are represented. Mr. Doctor appearing for the appellant fairly submits that there is for passing any orders insofar as Scan 1 of 2024 is concerned. Stop.
May I interject?
Yes.
In regard to serial number 6, my lord,
for the
Videography চলছে।
with
Vacated. Vacated.
no, my lord, last, if your lordship kindly takes, my lord, the last order, they were, my lord, Mr. Ghosh's client is, my lord, has been directed, my lord, to say, my lord, when they are going to affect the demolition, my lord. My lord, in the meantime, there is a tragic, my lord, tragedy, my lord, in the family of the landlord. One on 18th, my lord, one of the members have died, my lord.
You are appearing for whom?
For the appellant, my lord, in this.
Yes.
Appellants, my lord.
Yes.
So, my lord, one of the family members have died, my lord, just, my lord, on 18th. So, my lord,
He's not staying there, Mr. Prasad.
my lord,
The landlord is not staying in these illegal constructed premises.
Staying ground floor and first floor.
ground floor and first floor, my lord.
First floor and second floor.
No, it's okay with the landlord.
My lord, first
You are appearing for whom?
for the appellants, my lord, in this. That's, my lord,
The landlord.
landlord.
You are the landlord.
Landlord.
Then you are Ikramuddin.
No, I am for the respondent one, my lords. I am for Ikramuddin.
Then you are the landlord.
I also have a share in that. One of the shareholder.
Afzalul claims a part of the property through his mother.
That is me. That is me.
That is you.
Yes, yeah.
Then who are they?
They are also one of,
Co-sharers.
yes, they are also co-sharer in the same.
Co-share, my lord, in the property, my lord.
What are your names? Who are you appearing?
My lord,
Only Afzalul is
Afzalur Rahman
Died. He has
died, my lord. Then, my lord, stepped
Has
in the
been
suit, my lord. Yes.
No.
Sayyid Fazlur Rahman. एक तो यही ना है जी सर, उनका बेटा है, ये सब है ना, सब है ना, ठीक है, देख ले नाम देखिए। दे दे आपको
आपका जूनियर।
अच्छा ठीक है, अच्छा तो दे दो उनको
अभी कॉपी मिल
तब अभी है मजा है ना, अब तेलुगु ड्रामा डेथ सर्टिफिकेट देवें कर सकते my lord, these are the things, my lord, which are required to be, my lord, gone into, my lord, by your lordships, my lord. These are very, my lord. Okay,
Are you the only occupier?
No.
Before us, it is Afzalud and 3 other persons. Before us, it is Afzalud, Azizud is there. Azizud is there, Robiud there, and Sarfaraz is there.
And the
Are you appearing for them also?
My lord, thereafter substitution has been.
They are all co-owners. They are the sons of Afzalud.
Yes, my lord, yes. Yes.
You're appearing for them, I take it.
Yes.
You are only for Afzalud.
Okay.
Then you are not appearing for Azizud, Robiud, Sarfaraz.
Yes, I am appearing. Yes, my lord, all we are appearing, my lord. These are, my lord, all the sons and daughter-in-law, my lord. It is all, my lord, sons of the Afzalud.
Mr. Banerjee, you are appearing for whom?
But I am appealing for the state.
You are for?
Correspondent one, Ikramuddin.
What is the present status of the building?
So there are the present, my lords, the present status is that there are still some occupiers who are not ready to leave. I apologize. There are still some occupiers in the building who are not ready to leave even after the order has been passed for the demolition, and that is why he's appealing.
Demolition is of which portion?
Demolition of the extra floors that
Additional.
are additional floors. Yes, my lords.
There is there was a sanction plan in respect of first 2-story.
Yes.
But and above that,
They have built additional floors.
demolition is pertaining to that additional.
The additional floors, my lords.
I see. Now, in those additional floors, are they residing?
They reside in the first floor, right?
First and second. Azizud.
Azizud, yes.
Who is occupying the 4 additional?
Floors have already been demolished. My lord, 2 floors have already been demolished, my lord. Another 2 floors are there, my lord, where, my lord, it requires, my lord, demolition. দুটো ফ্লোর তো আর অলরেডি হয়ে গেছে
As per report, as per our report,
subsequently it could be learned from one Said Isadur Rahman, 51, so that his wife Manju Rahman, who was admitted in so hospital, had expired last night due to so failure. This is his husband, so Rahman. Their relatives and other resident building appeal to KMC and police authority to postpone the demolition. That is similar the report.
but আর এই সব বাকি 4 লোক থাকে তো আরে এখন
So these additional floors are being occupied.
It is, my lords, as per the instruction of my client, the additional floors are occupied by Sarfaraz, Irshad, and Sakrinuddin Farad.
Just a moment.
Yes.
Sarfaraz,
Irshad, and Sakiruddin.
Irshad.
As per the instructions of these are.
Give the names, Sarfaraz.
Yes. Sarfaraz, Irshad, Sakrinuddin, and Farad.
They are not parties here.
They are not party to this appeal. And
except for Sarfaraz, I don't find the other 2.
They are not.
They are tenants.
They are tenants. And 5th is by Afsar.
আবার ট্রান্সফার
you told us that you will give us the date.
asked me that create your lawsuit a particular date, when the demolition works shall be carried out. That told the demolition program had already fixed, and the last 2-3 days it is continuing, and today also they have gone to their place for demolition of the portions which are portions of the building which are vacant. But if your lordship says that in a particular day, on that particular day, the person.
So, Mr. Ghosh, today they are going to the premises. Right?
They have already gone.
They have gone.
I'm told. It's my information. And it is not carried
The
out.
problem is solved, then
Problem is solved, my lord. Definitely, my lord. It is then, my lord, it will be continued and it will be demolished. But the wood place, my lord, the portion which is found to be, my lord, unoccupied, that is, and my lord, the thing is, the entire factory building, the whole problem is the parcels are to be brought out, my lord, and my lord, the inventories to be made, whatever their articles are, how these things are
no,
there.
after we passed the order on 16th June, they said that give us some time because the festival is there.
That time was over.
Over. Now, after that, what has happened, Mr. Bush? You have instruction after 16th June. What happened?
Only information while I have received, my lord, that for the last my lord, 20th, schedule, my lord. Is it continuing today? Is it also been fixed? The police has also gone there. The whole thing is, my lord, that the
Some are not removed, some are not coming.
parcels are in occupation. That is the thing.
Now, Mr. Ghosh, can this be that you have after your program today and tomorrow, whatever it may be? Can you point out who are the persons who are not willing to vacate those premises?
So that of course, my lord, if you see direct I can, my lord, ask my officers to take the names of the parcels and which portion.
No, just tell us the flats, which flats they are not vacating. But your program is today. So you take instruction what had been the development today. And on Monday you inform us that this is our progress and this portion is remaining. Then we will fix the date. On which date the state the authorities will be, we will also direct the superintendent to deputy superintendent to see that the staff are safe on that particular.
And 20th June, 21st June, the demolition work was done and electricity line has been disconnected by the CSC. That is the report. এটা দিন থেকে আরেকটা দিন দাঁড়ান হড়বড় করবেন আমি দিচ্ছি আরেকটা দিচ্ছি একটা কপি দাঁড়ান না কপি তো একটা Lord, I am giving one another copy, Lord. Lord, this is the এটা দিন থেকে the last Lord, the paragraph, last page, the top. It was deferred on 19th June, but 20th and 21st, both the days, Lord, the demolition work was done peacefully, and Lord, the CSC disconnected electric line of unauthorized portion of the premises. My Lord has got it.
Paragraph.
Lord, this is the last page, but at top, report. My Lord has got it. 19th was fixed, but they appealed. That was responded. And 23rd June also, my Lord, the progress is going on. Your Lordship will find from paragraph 10 of the report.
time the 8 সপ্তাহ সময় করা গেছে ওরা নিজেরা একদিন সময় চেয়ে তারপরে কন্টিনিউ করছে
Very good, Mr. Banerjee. We will record your contention. You have also said that it is today also demolition work.
Yes, yes, report, my lordship, kindly keep the record, report.
We will keep the matter
Report.
next week. And your officer in charge will file a report before us, apprising us the steps taken on and from today.
But our steps to assist the corporation.
Yes, corporation.
Yes, your lordship, kindly, we are ready.
Mr. Ghosh's argument is we are today even demolition is fixed. We are going to. That
Your
is
lordship,
not-
kindly record that.
So we will say, we will record both your and ask your officer in charge to file a report before us.
Further report.
That what had been the further steps taken. Similarly, we will ask Mr. Ghosh's client to file a report before us as regards.
Where does it stand? What's that?
But Mr. Banerjee, the deputy, he must be in his deputy commissioner in charge. He has to be present there at the site, otherwise it will not happen. You please instruct the deputy commissioner because he says that 19th he was in paragraph 8, he says
Yes.
that the deputy commissioner was there at the subject.
Yes. Yes. Whatever requirement, blood, we shall take care of, blood, as per your lordship's direction, and we shall come with the blood, the progress report. So far as the assistance, blood, because your lordship kindly direct the corporation to tell us the date and time, we shall go over there and we shall assist the corporation regarding demolition. We are bow down, my lord. Lordship, kindly record that. আমি বাড়িতে ফিরে আমি বাড়িতে কি বলবো भैया नहीं है तब क्या झूठ बोल रहा है वापस नहीं रहा कभी बोल रहा है फर्स्ट फ्लोर सेकंड फ्लोर में वी आर नॉट ये टॉप फ्लोर में
Mr.
Lordship, this is my appeal, Milord.
Yes.
This is my appeal, Milord, representing Union of India on behalf of Departments of Science and Technology. Milord, this is the salient points of my argument. I will not be very explicit on only one or 2 points, Lordship. The issue which is, Milord, this is a institution which is the respondent number 1, Milord.
Mr. Dwivedi, what is the application about?
Stay application is there of the impugned order.
Is there any scope for any interim order?
Milord, just one interim order. Though we have prayed for stay of the impugned order, but if we can have consensus with my learned senior friend, Milord, the scheme of this institution is such.
Who are you representing?
Sir, Employees Association, respondent number 6 and 7.
What you are doing here? You are for whom?
But I'm for the writ petition, respondent writ petition.
Respondent writ petitioner, Lordship, Indian Science Congress and the General President. Then respondent number 3, Lordship, and they are the added respondents, Milord. Respondent number 6.
They were represented by the lawyers, I believe.
Milord, this point over here, Milord, we said the issue.
You are for the writ petitioners. That is the Indian Science Congress. And you are representing whom?
Sir, respondent number 6 and 7, Employees Association of the Indian Science Congress. And
so you were represented by an advocate. Where is your advocate?
Sir, we have expended so much money in single bench, sir. We don't have money. So I am appearing.
Where is your authority that you will appear for 6 and 7?
Sir, in can application 1, my all members have already authorized me, sir.
Can 1? Have you filed that can?
Yes, sir.
Not before your lordship. This was before the learned single judge, if I'm not wrong.
Yes. So then ultimately the advocate
Appeared, argued, heard. Affidavit filed, that was taken on record. Well, it's a considered judgment. It's the longest judgment, of course. Lord, may I suggest one thing, your lordships?
We have not heard Mr. Dwivedi.
Well, let my learned senior friend suggest. If a suggestion,
but I tell you, lordship,
then
not in the proper form, but all the documents are with the stay application. Well, this is, I tell you, lordship, I don't want to prejudice the mind of the honorable court, but this is a sentiment of Bengali. Sentiment of Bengali, this organization. This was established and organized by Sir Ashutosh Chandra Mukherjee. And then all the Bengali scientists, luminaries presided over the chair. Now, just because on certain occasions, certain grants have been granted by the central government, they cannot change my constitution, framed and approved by the government under the Society Registration Act.
Have you proceeded in contempt?
No, my lord, I have not yet. No, my lord, I'm saying, your lordship, since all the papers are there before your lordship, take up, my lord, for final hearing of this.
My lord, nothing has been done, my lord, which will invite contempt. My lord, what has happened, my lord? My lord, just say, my lord, in a nutshell, let me make lordship understand what the matter is all about. Indian Science Congress is an autonomous institution which was established in 1914. Now, my lord, nothing to do with the Bengali sentiments, lordship. From time to time, there have been various chairmen who were, even Dr. Bhabha was one of them, who was not a Bengali. So, my lord, be that as it may, it is not that. It is an institute of importance and heritage institution, my lord, which runs on its own bylaws, memorandum of association and rules. Now, lordship, they are getting grant from the Union of India, specifically from Department of Science and Technology from 1947. And that has continued till date. There was, my lord, a dispute with regard to our submissions. We said that we are giving grant them from 1948. My learned senior friend stated that they are getting grant from 1971. But there's a consensus that they are granting grant. That grant is to the tune of 99%, if not 100%, from the Union of India. Now, lordship, they also in their letterhead and other documents denote that they are a letterhead. they says that they are work under the aegis of the Department of Science and Technology, and that is a known factor all over India since time innumerable, of course, after independence. Now, Lordship, what happens is the employees who are around 20, 25 in number who are being allegedly represented by him are under the CCAS rules. They get paid in toto by the Union of India. And the other expenses.
In their case, CCA rules is applicable.
Yes, Lordship. Now they get paid from Union of India. Now, Lordship, what happens is then, and certain other amount of grant is also given, which is paid through which they pay statutory dues of income tax, other details, and also for running the institution. Now, this is where we are on a same footing. It's an admitted fact. Now, my lord, what happened was in 2017, they signed a memo. There was certain misappropriation. I will not use that word of defalcation, but misappropriation and also misuse of the government funds. And so there was a CAG report, which is the audit, which audits year to year, and which came to our knowledge, and therefore we wanted to make, made certain changes, and we make them sign a memorandum of understanding. If I'm wrong.
2017 itself.
I'm
In which year?
2017. 2017, this MOU was signed without any demur, without any
by the Indian Science Congress Association. So
there,
that their engaged staffs were also there.
No, my lord. What happens is staffs are all paid by Union of India, because the entire fund, 99% of the fund is given by Union of India.
So very good. Then thereafter, what MOU was signed? In
MOU was signed, which specifically says that you come under the GFR, that is General Financial Rules, and the other things. Subsequently, there too, what happened is, my lord, their president, who happens to be the respondent number 2 herein, by an electronic mail, which was produced before the Honorable Single Judge, but it did not form part of the record, which we want to bring it by way of the paper book or the supplementary, whatever it is. But that forms part of the order, because that has been dealt with. Now he agreed also. Yes, I am ready to accept the proposed changes in the regulations, in the rules and regulations, bylaws, and memorandum of association. Subsequently, there too, they changed their stand. And they called a meeting of the executive committee, which again we said, and they decided to file this writ petition challenging that proposal of the changes in their bylaws, rules, as well as memorandum of association, saying that we are an institute which has its own, if it is autonomous and it has its own flavor, we don't want to change our rules and regulations, because it will then change the entire institution itself. And it is the institution of which has fame, which has been there from 1914. So, my lord, the entire prayer is, my lord, first, there are rules and regulations which we intend to amend, or which we have recommended by our letter, that should not be allowed to be implemented, one. But the grant which is flowing from us should continue. These were the two major prayers of the writ petition. So our main contention before the Honorable Single Judge was, Lordships, that once approbate and reprobate. Once you have signed the memorandum of understanding, your president has accepted it. You cannot say no to it. One. Then, Lordship, we relied upon Ajay Hasia's case, which was followed by other judgments, which says if an institution is given 99% grant, it comes under the GFR, and it is under Article 12, it's a state. Now,
then, Mr. Dwivedi, now today there is no scope for any interim order.
My lord, my lord will kindly give me 30 seconds. I've given you, my lord, a basic factual mystery, my lord. Now, my lord, what has happened is, after this order, initially, the bank accounts, there are two bank accounts, where every year 5 crore rupees is remitted by the union. Now 3 crores goes to the RBI account from where salary is paid to the employees. There is no issue because DST, according to the old rules and regulations, representative of the DST happens to be the secretary of the executive committee. So he is the signing authority as far as those 3 crores is concerned for disbursal of salary. Now rest 2 crores is transferred from the RBI account to the account, SBI account of Indian Science Congress. Now, Millard, what happens is from that account, the signatory. No, Millard. Signatory now is the Union of India's representation, who is the treasurer, who is the treasurer? Yes,
2 crores.
2 crores, and the representative of the DST, who is the secretary. Now, as at present, they are the same. But, Millard, what we tried to implement was that initially, according to the old rules and regulations, the treasurer happens to be an elected member of the association. So he was one of the signatories, which he is not there anymore because the representation is by the treasurer, who is appointed by Union of India, and the secretary. Now, Millard, after this order, that 2 crore account, which is required for disbursal of income tax and other statutory dues and the day-to-day expenses of the association, cannot be operated because the committee is not allowing the treasurer, who ordinarily happens to be an elected member of the body. He is no more there. There is our representation. Our representative is the treasurer now, who has the signing authority. So, under those circumstances, that account is not operative, and no payment can be made for the day-to-day expenses of the institution and other statutory dues of the institution. Now, if my lord allows, what I was wanting my learned friend to understand, that for a limited period, because it's our fund, and even in the judgment which is impugned before your lordships, the honorable single judge of this view that yes, we have all right to say regarding the funds. What the honorable single judge says, that you are entering into the administrative affair also, which we will say, I join issues lordship, but then that is the sum and substance of it. There were 2 segments of the honorable single judge. He said that finance, yes, you are entitled to, because you are providing the entire fund. Now, but administration, when you are changing the executive committee, when you are changing the rules and regulation, it takes away the basic flavor and the heritage of this particular institution, which you cannot.
So now who is the operator?
My lord, operator are my representatives, that is Union of India in toto. One, under the old rules, my lord will kindly see, under the old rules, one represent.
So then what is the interim order you are wanting?
Interim order that the payment, the 2 signatories who were signing the check, as far as that amount SBI account is concerned, my lords, they continue for a limited period till the paper books are coming, so that all the expenses, because all the expenses are being audited by CAG, and it is our funds. So, my lord, that will be more conducive for the institution to run till the time this appeal is heard and disposed of.
So now,
my lord, and that will take care of their rights also, who are the employees.
Presently, they are not getting.
Now, they are, after this judgment, they are not allowing the treasurer to sign, because they are saying that according to the bylaws,
they are not allowing your treasurer to sign. Treasurer is their committee member also.
No. Now after we implemented our rules, we appointed treasurer from our side, because
but treasurer from your side is not a member of the committee.
Not at all.
My lord, after the CAG report, my lord, I stand correct. After the CAG's report, the executive committee was suspended by the Union of India. And therefore, in order to run the institution, a treasurer was appointed by the Union of India, for who is the employee? Who is the employee of the association itself?
Oh, he is an employee of
the association itself, because they are paid by us. So a treasurer was appointed by us. Now the issue is that after this judgment, we do not have the right to nominate the treasurer. So if our treasurer is not allowed to sign, then nothing will happen.
So
and
there
if
will
they
be a stalemate. the other members won't be able to.
No, my lord,
get
because the treasurer is, because the committee is suspended now.
How can you, Lord, there was nothing before the court below that the committee was suspended.
So
There
now,
was nothing
let
before
us
the.
understand, Mr. Sandal, now that amount of yearly grant of.
Lord, I will not take the grant record that. I will not take a single na paisa from the government record.
Then what about the employees?
That's not your headache.
Now,
That's not the headache of the government.
employees 3 crore, that is separate.
But my lord, why? If I take a grant, I will take it in toto. Because the Article 12 stares at them,
No, you
and there
said
are judgments.
3 crore is for the employees of the
My lord,
association.
I give total 5 crores. Since the
We understand that 3 crores is for the employees. That amount can be withdrawn by your official. So there is no problem with that. So far as 2 crore, which you are providing for the Congress, they are also saying that we will not withdraw the amount.
But my lord, what about the
Lord,
statutory
entire
dues?
amount is.
What about the, my lord,
What about
kindly
the- yes,
appreciate
yes.
the statutory dues,
Hmm.
such as kaun sa tag?
So you
Income
come,
tax.
come with some sort of material that you want disbursement of this much for towards the statutory.
My lord, if my lord gives me a breather of a day, my lord, just a day, my lord, I will be make a very comprehensive, because that is the only thing we want, my lord, at this point. कौन सा पेमेंट SBI अकाउंट से
বলেছি তোরা করতে পারিস না
No,
2 crores is being operated by their members.
no, my lord, what bone of contention is not that. I was trying to abridge what interim relief I want. Because, my lord, my bone of contention is an institution which comes under the GFR, General Financial Rules, and we have all the right under the sun, as per the dictats of the Honorable Supreme Court, in Ajay Hasia's case, to run and control and make amendments.
What were you doing since 1971?
Well, we were adhering to the, we don't, Lordship will kindly appreciate.
No, that.
As far as all these institutions are concerned, they have their own bylaws and they run it according to their own bylaws. We don't interfere. But when we see that there has been manipulation, personal aggrandization, there was a CAG report that
show us this 3rd May 2023 order and 8th June 2023 order.
Lordship will allow me to first place, third, give me.
We are not appreciating what interim protection you are wanting. As we
Interim protection
understand
just
from
in
the
order to
order,
disperse the provident fund, gratuity, and the pension, and this which will go from 2 crores.
There in these 2 memo, 3rd May 2023 and 8th June 2023, those are pertaining to alteration of rules and regulations.
Alteration.
So where from you are getting this?
My lord, may I, my lord, I apologize, my lord, I cannot explain it to my lord, but I'm trying my level best, my lord. The dispute started with regard to amendment of their bylaws, memorandum, and their rules. Because we championed for the cause that we are providing the grant, therefore you come under the purview of Article 12.
Understood.
Now,
Yes.
now, my lord, that was the only contention before the Honorable Single Judge.
Right.
Now, the Honorable Single Judge, at that point of time, why the writ petition was pending.
So set aside that, saying that the original system will continue.
System. But what has happened is, during the pendency of the writ petition, because of the financial defalcation or what the committee was suspended by Union of India.
Where is that?
That
never
not even
communicated to us. Sorry.
My lord,
Mr. Dwivedi, you show us, if it is suspended, then there must be some terms and conditions in the suspension letter.
My lord, then suspension.
You show us, unless you show us, how can we say about that?
It was not in the writ petition. My lord, it was not on record, but my lord, what I say, when it was.
Mr. Trivedi, if
My
it is not on record, so what we understand is the challenge in respect of two communications by which you said that you change your rules and regulations.
Lordship.
So that has been set aside
Lordship.
by the trial judge.
Right.
Now, for reviving those said memoranda, the appeal needs to be heard.
Lordship.
But in the midst thereof, which you say that due to this financial defalcation, we had issued already a suspension order, then we have to consider then how, who will be the authority during ceasing of the suspension order to operate the bank accounts. Then now you can show us that this is our prejudice, defalcation is there. So if they take away the money, we will be in problem.
Because this was happening while the writ petition was pending and it was within their knowledge. This disbursal of provident fund and gratuity to the people was being done during the pendency of writ petition by the treasurer appointed by us.
Now, according to you,
They are my employees. It's my headache. What am I to do with them? They entered into my employee, not with the picture that the central government will pay them.
that you are being a bit harsh.
No, not bit harsh. I tell you, Lordship. I tell you, Lordship.
You
So for the
cannot say
grant,
just now.
now I
that
tell you, so
central
for the employees, they are paying to their account. Let them pay. I don't bother about that. Now, think over it, your Lordship. I mean, society under the Society Registration Act.
Very good. Now we are in ceasing of the appeal.
Do that. That's why I'm saying, your Lordships, to avoid all controversies, since all the papers with this stay application, your Lordships, hear it out.
All appeals we have to hear it out.
But not, this is some importance, your Lordships. Some importance.
Mr. Trivedi, you make
My lord
up
will
the
kindly say
case
how
of
they use the
There's
letter.
nothing
Will
before the
kindly
learned- kindly see nothing before the learned
This
signature.
is the letterheads which they. Lord,
No,
it
my
is
lord, this-
my money and it is being paid for the provident fund. My lord will kindly allow me to pay the provident fund, gratuity, GST, income tax of Indian Science Congress and pension, because that is.
Show us the amount, Mr. Trivedi.
My lord will kindly bear me
We
for.
give you a supplementary affidavit leave. You incorporate which amount of
My
money
lord, if that amount is.
required for the benefit of the employees and
I shall.
so then we will consider Mr. Sannal's argument.
My lord, I bow down.
Mr. Sannal's argument is we don't want your money also. No, Mr. Sannal argues so far as that amount which you are wanting to withdraw,
Lord.
you explain that why you are wanting to
My lord,
withdraw.
we
If
shall.
that is the quantum which is to be withdrawn for the benefit of the employees, then we will hear Mr. Sannal. Apart from that, the other fund will be there as it is because that alteration has been set aside.
my money is also there, my society's money in the same account.
That is why we are wanting to say that what is the quantum? What is the quantum he wants?
What has fallen from my lords is that we will buy a. Understand what I'm trying. Their cause and saying that that amount is not required. My lord, be that I am not.
No, we have.
My lord, I am not joining issues here, my lord. What has fallen
No,
from your
we have a
lordship?
filter in our ears. We hear something.
Now, my lord, one more submission to your lordships. Before this controversy, entire amount was being disbursed by us through our age-old mechanism. No dispute, nothing, except after 2023, when some new persons came in the picture. Now, all that I want, let's suppose I'm taking money under the GRF rules. GRF rules provides that if there is any mismanagement of the fund, misappropriation of the fund, defalcation of fund, the government is not remediless. They can take steps against us. Now, why are you trying to step into my shoes? If you find in according to your CAG report, there are certain things which is not correct. I'm saying with all humility and with all responsibility. There was no defalcation of fund. So I should run my account. Why the government will run my account? Just because they have grant, they have given grant. If I not used properly, well, this is the general rule. The government will withdraw the fund or stop the fund. Then why are you trying to step into the shoes of my office?
So
Just to occupy it.
since when you are not being allowed to operate?
Just after filing the writ petition.
After
filing the writ petition.
So
it's being hard on being
that suspension came.
No suspension, your lordships. I'm sorry.
This argument, this development came before the single judge also. It was not said.
No. We know. They were trying to do certain things. Even our president was not.
Prior to this May communication, who was operating?
We were.
So you are being stopped from operating that fund since
after this
since the date of issuance.
So this is the situation.
After
suppose I tell your lordships, a person.
No, Mr. Sannal, if the statutory dues which are required, how can you withdraw
I pay my statutory dues. It's my office.
No, you
I
have
put it
lost.
like this, my lord.
You have lost. They are expressing that you have lost their confidence.
Malak is absolutely vague.
Let us understand, Mr. Sannal, let us understand if there is a statutory due amount, if that is taken by the said signatories for the purpose of your employees, how can you be prejudiced?
With all respect,
So far as the question of the remaining amount, operation of which now vests upon you in terms of that will decide.
I tell you, Lord, even the grant is given to me.
Yes, whatever it may be.
Kindly.
No, for this, you cannot have any plea as regards the statutory deduction.
I tell you, Lord, I'm not. I will pay statutory due.
No, you don't pay. As a stopgap, we will make that.
Well, let them come up what they will pay. Let's see.
Yes, yes, my lord.
Let
We
them
shall
up.
come.
Yes.
Only,
Because
only.
I take your losses point.
Now, Mr. Sharnal, if to that effect you find any difficulty, that you will express to us.
That's true.
And if it is not, we will make the fund operational in respect of that 2 crore, say for a particular period of time for withdrawal of that statutory
I
dues.
totally bow down.
And we will hear out the
Totally bow
appeal,
down.
Mr. Sharma.
I totally bow down.
And
my
we
lord.
will
We are
fix
coming.
a date and hear out the appeal.
Well, can you let them come up? Let's see.
In course of hearing, Mr. Dwivedi learned appearing for the কার্তিক ওই যে
was set aside. So that is one WPLRT. And the other was for mutation. They said since the land has been resumed by the state, the question of mutating my name in the land record does not arise.
Assumption has been set aside by the tribunal.
So consequentially, the order was passed for recording my name. For last 8 years, they are not doing that.
Now they have come up with a review.
No, no, not now. The review has been filed in.
After the dismissal of the special petition.
Copies, review applications, copies are
Yes, yes.
No, but if the,
Copies
your lordship will kindly visualize the situation, 8 years. Well, not only 200 acres of land, I am not being able to utilize my land.
8 years we are waiting for 8
lord.
days. It will come up.
No, my lord,
Review
on the
applications.
previous occasion when the matter came up, well, the submission was the same. So every time the matter comes up,
This review been tagged, Lordship.
Review number কত? What are the review numbers?
Hmm.
এইগুলোকে দুটো রিভিউ আনিয়ে এটা
one is R 166 আর একটা কত?
It's the department, Lordship.
So you assist our officers, that is not being, we have sent for requisition, but it is not coming.
My lord, allow us to reconstruct. We will do it. আপনি করে দিন।
অ্যাসাইনমেন্ট আর সব ছেড়ে দেবে জি আমার কাছে পাবে।
একটা রিভিউ না দুটো রিভিউ?
দুটো রিভিউ।
166 তার একটা
166 165 বলছে।
এটা তো রিভিউ
এই যে।
কপি আছে।
166 165
কই আছে আপনার কাছে?
আমার কাছে আছে, আগে তো কপি
You filed the review in the department.
কেউ কপি সার্ভিস করে দিয়েছি।
And we have served the copy. They have also
I have it.
copy.
Yes.
তাহলে ট্রেসে নয় তোমাকে কে বলছে? তুমি একবার গিয়ে নিজে গিয়ে বলো কোড ফিক্স করেছে।
ওটা নাকি পাওয়া যাচ্ছে না।
নিজে গিয়ে একটু বলো কবে রাখবো বলো তোমার তোমার the review
Very well, madam.
applications.
Otherwise, your lordship will give us leave. We'll reconstruct. We have copies. We'll reconstruct.
How will you reconstruct their application?
No, but if they don't do it, I will reconstruct it.
We'll give copies to them, then question
Very
of
well.
reconstruction. Let us ascertain from the, if it is in the department, it will immediately come.
Very.
Next Wednesday, রেখে দাও। Yes.
Next Wednesday. Great.
The last of it we have served copy.
Lordship, may I pray one thing, Lordship? If your Lordship direct the department to with an order, Lordship.
That deduction is already there before it was assigned.
Lordship.
You also please help our officers where you have filed it. If you can tell the details, my officer can also text.
Lordship.
Great.
Yes, next.
ওই অর্ডারটা থাকবে তো? ওই অর্ডারটা
Yes. Item number? The combined list. Oh, আচ্ছা। 55.
55 তো দীনেশ কুমার বলছি।
Homeland ডাকছে।
আমার জমাদার করবে, ঠিক আছে? দেবাশিসকে আমার জমাদার থেকে গোটা করে
কোনটা দিয়েছো? ওই দেখো মোটা অ্যাপ্লিকেশন আছে, সব কাগজগুলো সাথে আছে, প্লেস করছিল যেটা। দুটো অ্যাপিল নাকি না একটা? Which one are you placing, Mr. Mitra?
My lord, kindly take up MAT 898 of 2024.
No, no, it has got its FMA number. You are placing from the application for stay filed in connection with that.
দরকার ছিল
না, এখন করে নিয়ে পড়ুন স্যার, এত অসুবিধা হবে আপনার।
You are appearing for Taposi seat.
Lordship, for the appellate.
And the other appeal?
My lord, their two writ petitions were disposed of by a common order. By the order impugned, my lord, the services of my client, the appellant, my lord, which was, my lord, which happened in 2008, was, my lord, cancelled.
Oh. Yes.
But kindly take the order impugned, my lord, that.
Is it annexed to your stay application?
Yes, my lord, it is, my lord. Kindly come to page 190. May I place it, my lord, and proceed, my lord, on the basis of the impugned judgment?
Yes. Yes.
The facts needed to be adumbrated for effective adjudication of the writ petition are as follows. One selection process was undertaken by the managing committee of Bajkul Balai Chandra Vidyapit to fill up the post of Group D in the school, one post, my lord, of a matron. The concerned employment exchange was asked to sponsor the names of eligible candidates. In addition thereto, by an advertisement published in a leading newspaper, applications were also invited from the eligible and intending candidates for the post. In response to the advertisement, one Srimati Taposhi Sheth, the writ petitioner in WPA number such and such, claiming herself to be an eligible candidate, offered her candidature for the post. In terms of an interim order passed in a writ petition vide such and such, the petitioner in WP number, namely Bithika Shingho, hereinafter called as Bithika, was allowed to participate in the selection process. On 9th August 2008, an interview was held, and on the basis of the marks obtained in the interview, Taposhi was placed at the top of the panel. Bithika secured second post in the panel. Taposhi joined the post on 26 September 2008. Bithika lodged a complaint to the competent authority alleging that Taposhi could not pass Class 8 examination. An inquiry was commenced and the same was concluded by the additional DI of school, declaring that the progress report, which Taposhi submitted as proof of our educational qualification, was genuine. Finally, additional DI of school vide his memo dated 12 September 2007 approved Taposhi's appointment in the post with effect from 26 September 2008. Bithika questioned the legality of Taposhi's appointment by preferring a writ petition vide WP number such and such. Taposhi was implemented in the array of the respondents. By an order dated 30th April 2009, the writ petition was disposed of, directing Bithika to place a copy of the writ petition along with all annexures thereto, to the Director of School Education, who was directed to consider the matter in proper perspective after affording an opportunity of hearing to Bithika and Taposhi and take appropriate action in accordance with law within a specific time frame. In deference of the said order, dated 30th April 2009, the Director of School Education decided the issue, and in his order dated 28, it should be 28 September, not 28 June, 28 September 2010, he expressed his doubt regarding the genuineness of the Class 8 pass certificate of Taposhi, and eventually he rejected the candidature of Taposhi. My lord, kindly pause here for a moment. Kindly come to the, my lord, the report of the kindly give me a minute. Sir. 28th September. Sorry, yes. Kindly come to my lord 136. 136.
Essential. Yes, page 136.
Yes.
This was the order passed.
Yes.
Then what happened?
My lord, then my lord, kindly come back to my lord. The impugned or
Page
impugned order
190
simultaneously by the said order dated 28 June 2010, the Director of School Education cancelled the prior permission, approval of panel, and the approval of appointment of Taposhi. The director concluded the order directing the DI of school to forward the vacancy to the concerned Regional School Service Commission in terms of the notification dated 9 September.
By the same order.
Yes. The order of the Director of School Education dated 28 June 2010.
It will be September, na? September.
September. No,
28.
no, June. I made a mistake. Well, it is June.
It is June.
Yes.
Yes.
The order of the Director of School Education dated 28 June 2010 dragged both of them in this legal battlefield and forced them to institute two different writ petition with a WPA number such and such and WPA number such and such. The first one was instituted by Bithika challenging the concluding part of the order whereby the prior permission was cancelled, and DI of school was directed to forward the vacancy and seeking her appointment in the post after recasting of panel, whereas the second one was preferred by Taposhi, assailing the entire order of the Director of School Education to save her job. By an interim order passed by a coordinate bench of this court on 9th August 2010, Taposhi was allowed to continue to render her services in the post on the following words. Until further order of this court, her services shall not be disturbed. However, it is made clear that Srimati Sheet shall have to bear all consequences if her writ petition fails, and she shall not claim any equity. The learned advocate appearing for Bithika seeks to contend that the essential eligibility criteria for the post was Class 8 passed from any recognized school. Inviting my attention to the progress report of Taposhi, he argues that Taposhi secured only 169 marks out of 900, and she could not secure pass mark in any subject except in work education, but somehow managed to get promotion in the next class. he seeks to urge that even in the oral examination of second language, Taposhi was awarded 11 out of 10. Taking me to annexure R4 to the affidavit in opposition used by Bithika as private respondent number sent to Taposhi's writ petition, it is contended by him that while giving response to application of one Shapon Kumar Bormon preferred under the relevant provisions of the Right to Information Act, the West Bengal Board of Secondary Education declared that Taposhi could not be declared to be a Class 8 pass candidate. My attention was drawn to annexure R5 of the same affidavit to contend that though in the same academic year, some students secured more marks than Taposhi, but it was only Taposhi who was promoted to Class 9 for some mysterious reasons. Now, my lord, kindly pause here for a moment. Kindly come to page 176.1.
Yes.
Well, this was the application under the Right to Information Act. Has the headmaster, headmistress any residuary power to promote students in the examination? What were the norms of passing the class 8 in 1986? Please respond to the question with documentary evidence. A student of class 8 has failed in all the subjects except the work education group in the annual examination. Under such circumstances, is she eligible for passing the annual examination of class 8? Was there any no detention scheme in case of promotion in 1986? Now, these were the queries. Now, kindly come to page 177. The response. 1. In terms of Rule 33 of the Management Rules of 1969 for aided, unaided, non-government institutions, the head of the institution shall ordinarily be guided by the advice of the academic council in the matter of promotion of students in the examination. But the head of the institution may, for reasons to be recorded in writing, overrule the advice of the academic council. In that case, any member of the ACA council may be in disagreement with the decision taken by the headmaster, then the matter may be referred to the managing committee of the school, whose decision thereon shall be final. Then kindly turn the page. The general norms of passing any student in any class in 1986 were that the student shall have to obtain pass mark in all subjects. However, in exceptional circumstances, results, that is promotions, are generally discussed in academic council, whose decision may be referred to the MC for consideration and final decision. After the implementation of the comprehensive and continuous evaluation system since 2007, some criteria have been introduced for promotion of students in different classes, which have been published in such and such. Then kindly come to my lord number 4. In 1986, there was no detention policy at the primary level, not in the secondary level for promotion. Now, my lord, in this connection, kindly also come to the next page. The particulars which were sought for, and kindly come to page 181. In response to the aforesaid application, etc., kindly come to 1. As per the annual mark sheet, etc., kindly come to 2. Under special circumstances, if the MC and academic council of the teachers consider the result of such candidate and approve it with a resolution adopted unanimously in the meeting by the majority members, specifying genuine reasons behind such poor result of the candidate and expecting better result in the next class, the school authority may allow her promotion to next class on consideration. And 4, it is the normal rule to pass any student who shall have to get at least such and such. considering the pros and cons of students' scholastic and non-scholastic aspects throughout the year in teaching and learning situations in different classes, Academic Council may recommend any student for promotion with the help of resolution taken unanimously in the meeting of the Academic Council as a special case. Lord, this was the response.
Yes.
Now, my lord, in this connection, my lord, kindly also.
Taposhi was promoted to class 9 for some mistake, referring to a report of the board and its analysis seeks to argue that in terms of the exam, board has declared that Taposhi could not pass class 8. Where is that?
I really could not find it out.
Next, please continue, Mr. Mitra. Then what happened?
Well, let kindly once come to page 143.
143.
Yes.
This is the report of the board. Order dated 9th August. Yes, what you want to show?
Yes. Kindly come to the second paragraph. Number 1, Srimati Taposhi Sheet. Number 2, Srimati Bithika Singho, Prashanto Kumar Bera, Secretary. These are the persons who were hurt. And the headmistress, Bhupati Nagar, so-and-so Vidyalaya, Purva Mednipur, attended the hearing. Now kindly turn the page. Or kindly come to the bottom of page 143. It indicates from the said document that Srimati Dhali got such and such out of such and such in language group, 40 marks out of 300 in science group, and such, and her people group that is below the qualifying marks. Then kindly turn the page. She was second line. She was promoted on consideration, but the headmistress could not produce any evidence showing application of residuary power by the school authority. However, she stated that there was a practice in the school for granting promotion in some cases on request from guardians. The attendance register produced by the headmistress show that Srimati Taposhi Sheth was permitted to attend in class 9 and was given transfer certificate original on 23rd November 1990 by the then headmistress of Bhupati Nagar Kanya Vidyalaya, declaring that Taposhi Dhali left the school on 22nd May 1987 as a student of class 9. Then kindly omit the next paragraph, kindly come to the paragraph thereafter. It may be mentioned in this connection that according to the norms in the board syllabus prevailing in 1986, pass mark in a group was such and such and minimum qualifying mark in a subject was such and such, stipulating conditions that the principle may be followed by the school in the annual examination. A copy of the relevant page of the board's relevant syllabus book is enclosed. But as per Rule 30 Sub-Rule 3 of the Rules of the Management of Recognized Non-Government Institutions Aided and Unaided, 1969 as amended, the head of the institution who shall ordinarily be guided by the advice of the Academic Council regarding promotion of students has the power to overrule the advice of the council. A copy of the said rule is enclosed for ready reference. It therefore follows that the school authority has some residuary power to promote a student. And in this connection, kindly come to kindly come to page 145, the rules.
Yes.
The Academic Council, my lord, kindly come to Rule 30, then kindly come to Sub-Rule 3. The council may discuss matters connected with admission, promotion, selection of book, timetable of school hours, and measures relating to the improvement of teaching and co-curricular activities. The head of the institution shall ordinarily be guided by the advice of the council in matters specified above. But the head of the institution may, for reasons to be recorded in writing, overrule the advice of the council, in which case any member of the council who may be in disagreement with the decision taken by the head of institution may refer the matter to the committee whose decision shall be final. And then, my lord, minimum marks, next page. Are given, my lord, that's not very important. Now, my lord, this was the report of the president, my lord, and my lord, that thereafter, my lord, the parties came up before the court. Now, my lord, kindly come back to the impugned order, the judgment.
Yes.
My lord, kindly come to.
You are placing 194.
Yes. Thereafter, my lord, kindly come to, my lord, the internal page 7. 196. My lord, the second paragraph. Heard the learned advocate and peruse the materials on record. Therefore, the epicenter of the dispute in the case at hand has brewed up on a primal question whether or not Taposhi passed Class 8 examination or whether or not Taposhi could be treated as an eligible candidate for the post. A bird's eye view of Taposhi's progress report will reveal that Taposhi secured only 169 marks out of 900 marks and she failed to secure qualifying marks in any of the 3 subject-wise groups. She was awarded 38 out of 100 in work education group. Admittedly, in oral examination of second language, Taposhi was awarded 11 marks out of 10. In the report of the board, in unequivocal terms, it was declared that Taposhi, who secured 54 marks out of 300 in language group, 40 marks of 300 out of 300 in science group, and 37 marks out of 200 in the group of such and such, had failed to pass Class 8 examination. As such, having failed to secure 30% in the aforesaid 3 subject-wise groups, she could not pass in the annual examination of Class 8. Taposhi was promoted to Class 9 on consideration. From Annexure R5 referred above, it would be explicit that a certain number of students securing more marks than Taposhi had not been considered for promotion to the next class by the school authority. But for some mysterious reasons, Taposhi was promoted. The school authority concerned under the impression of having unfettered power to award promotion, promoted Taposhi to the next class. Taposhi did not continue her studies but utilized her progress report to secure a job in a government recognized school, claiming her to be a Class 8 passing candidate. Pausing here for a moment, my lord, she obtained this, my lord, at least 10 years back. Not that, my lord, she left the, my lord, school for this, or she somehow got it for this. It is unfortunate to comment that a school authority which comprised of respectable teachers engaged in building moral character of the students and imparting quality education to them for the reason best known to them had promoted Taposhi to next class, keeping either other identically circumstanced students stuck to their old class only to facilitate her to use such progress report as a Class 8 pass certificate. Now, my lord, again pausing here for a moment, my lord, it was nobody's case, my lord, that the authority the school authority or my lord, the school administration did not have the authority to grant the promotion. I shall show your lordship, my lord, the report, their affidavit. I have shown your lordships the report. I will show your lordships the affidavit filed. Next, last paragraph. In this legal battlefield, Taposhi suffered a serious blow when a coordinate bench of this court, in its order dated 30th April 2009, passed in WP number such and such, observed that the private respondent Taposhi did not in fact qualify in the examination held for Class 8. Taposhi accelerated her defeat, leaving the order dated 30th April 2009 unchallenged. In a quick succession, she suffered another blow when the board in its report in unambiguous words declared that Taposhi could not pass Class 8 examination. And eventually she suffered a fatal blow from the order of the Director of School Education in which her candidature was cancelled.
Yes.
Now, my lord, kindly once again, my lord, kindly Director of School Education, page 71.
এটা কোথায় বলি ওর যে ওর বলে দিচ্ছে যে ও পাস করে কোথায় বললি যে পাস করে
এখানটা তুমি দেখো এখানে বক্স examination of class 8 for her failure in the 3 groups.
She was promoted on consideration. Yes.
Now, my lord, kindly once come back to this last paragraph at internal page 8. In this legal battlefield, Taposhi suffered a serious blow when a coordinate bench of this court in its order dated 30th April 2009 observed that the private respondent Taposhi did not in fact qualify in the examination held for Class 8. Now kindly come to this order once. My lord, kindly come to page 67 once.
Yes.
Kindly come to page 68. The last paragraph. Kindly come to the last paragraph. Question first arises as to whether the present writ petition
yes,
challenge such appointment on the basis of such progress report being annexure P5. It is clear that the private respondent did not in fact qualify in the examination held for Class 8. Out of the total marks of such and such, she could not even get the total qualifying marks. It cannot be denied that he was promoted. But was the nature of consideration for such promotion is not certainly clear from the said document. The progress report does not specifically mention that she was considered as Class 8 pass candidate. It sometimes happens that a student is given such promotion in order to enable him to enjoy a higher class in another institution, but that is not the issue for adjudication by this court. In absence of any clear material showing that the selected candidate, being the respondent number 8, was eligible to be considered for recruitment in Group 8 post, I am afraid this court cannot afford to remain a passive onlooker. The decision in the case of such and such is in a different perspective. It may, however, be mentioned that the said respondent number 8 has already been appointed and he has reportedly been discharging his official duties and receiving salaries. Considering all this aspect, I think that interest of justice would be best served if the present writ application is disposed of with direction upon the Director of School Education, being the respondent number 2 herein, to consider the matter in its proper perspective. Now, this was the order. Now, kindly come back to the impugned order, page 8, which I placed before your lordship. In this legal battlefield, Taposhi suffered a serious blow when a coordinate bench of this court, in its order dated 30th April 2009, observed that the private respondent did not in fact qualify in the examination held for class 8. The next part of the order, my lord, is not taken into consideration.
Now, where is this quoted portion in page 68?
Yes, kindly come to my lord, page 68, last paragraph. Third line, it is clear that the private respondent did not in fact qualify in the examination held for class 8. Out of the total marks of 900,
This observation went against you.
yes, but kindly look into the next part of it. It cannot be denied that he was promoted. But what was the nature of consideration for such promotion is not certainly clear from the said document.
Yes.
The progress report does not specifically mention that he was considered as class 8 pass candidate. It sometimes happens that a student is given such promotion in order to enable him to enjoy a higher class in another institution, but that is not the issue for adjudication by this court.
Whatever and however it is.
Yes.
Now, my lord, on the basis of this order, my lord, the director school education had passed the order that I had placed before your lordship, my lord, possibly page 71. Now, that order was challenged, my lord, in the two writ petitions.
করলে অর্ডারটা তুমি দেখালে ডেট অর্ডারটা হ্যাঁ 143 আমি ওকে হেডমাস্টার পাস করাই ইয়েস 143
Now, my lord, as I have submitted before your lordship that the order was challenged, my lord, by filing two writ petitions. Now, my lord, in that, my lord, an interim order was passed. My lord, kindly come to page 141. Kindly come to, my lord, the first paragraph. The President, West Bengal Board of Secondary Education, is not a respondent in either of the two petitions. For the purpose of effective adjudication of the issue raised in these two petitions, the presence of the President is considered necessary. Then, my lord, the respective petitioner shall implead the President. Next, the learned senior advocate for the petitioner in WP number such and such, Taposhi, has produced before this court original of the duplicate progress report for the year 1986, issued in favor of his client by the authority of the school. It appears therefrom that Taposhi was declared promoted on consideration, although the marks obtained by her in different subjects prima facie did not warrant her promotion. Be that as it may, without expressing any further opinion on the issue, this court considers it proper to obtain a report from the president of the board as to whether, on the basis of the marks obtained by Taposhi at the half-yearly and annual examination of the 1986, conducted by the said Vidyalaya vis-a-vis the rules regulations of the board that were existing at the time she took half-yearly and annual examination referred to above, she could be declared to have been promoted to class 9. The president of the board shall decide the issue upon granting Srimati Sheet and Bithika Singh and the authority of Bhupati Nagar reasonable opportunity of being heard. The report shall be placed before this court. The president shall also indicate in his report as to whether the school authority enjoys any residuary power to promote a student, although she may not have qualified for promotion according to the board's rules regulations. And on that basis, my lord, the report was submitted, which is at page 143, which I placed before your lordships, my lord. Hearing was given to
এটা সেকেন্ডটাতে ডাইলিউট করেছে প্রেসিডেন্ট উইল ইন্ডিকেট ইন যে ওয়েদার স্কুল অথরিটি এনজয়স বোর্ড হোল্ড করে প্রেসিডেন্ট পাওয়ার আছে বাট এটা ডিপেন্ড করে
President shall decide the issue upon granting so what is this issue? Whether she will declare to have
help hide the issue.
If class 9
as to whether on the basis of the marks obtained vis-a-vis the regulations that were existing. president will.
She could be declared to have been promoted to class.
হ্যাঁ
এটা হচ্ছে issue.
বলে দিয়ে প্রমোশন করতে পারে রেসিডিউয়ারি পাওয়ার আছে।
এটা হচ্ছে ইস্যু। এটাতে বোর্ড বললো হ্যাঁ রেসিডিউয়ারি পাওয়ার আছে করে দিল।
So your argument is that the issue which was relegated was as to whether she can be declared as promoted. That
And-
has been held in your favor.
And my lord, the president has given the report. Kindly come to page
That
1.
it has residuary power.
And now, my lord, kindly take up the, my lord, the affidavit in opposition filed by Bithika to my writ petition.
Yes.
Now kindly come to page 148. The affidavit filed by Bithika in my writ petition, my lord, kindly come to page 148.
Yes.
Kindly come to page 151.
Yes.
My lord, subparagraph 6 of paragraph 3 at page 151. It is stated that pursuant to the direction passed by the Honorable Justice so on 28 September 2010 in WP number such and such and WP number such and such, it transpires that the President of West Bengal Board of Secondary Education has passed an order, the operative portion of which is quoted below. Then, my lord, kindly come to page 153, subparagraph 7. After perusing the order dated 28 September 2010, passed by the President of West Bengal Board of Secondary Education, it transpires that it was observed that Srimati Taposhi Sheth was promoted on consideration, but the headmistress could not produce any evidence showing application of residuary power by the school authority. And there was a practice in the school for granting promotion on some classes on request from guardians.
Issue which was relegated was that promoted হয়েছে সেটা বুঝেছে সেই জন্য অপোজিশন এটা
First part, she says that, my lord, the headmistress could not produce any evidence showing application of residuary power by the school, and there was a practice in the school for granting promotion in some classes on request from guardians. It is stated further that the President of West Bengal Board further indicated that as per Rule 30 Sub-Rule 3 of the Rules of Management of such and such, as amended, head of the institution shall ordinarily be guided by the advice of the Academic Council regarding promotion of students, and the President of West Bengal Board of Secondary Education further commented that the school authority has some residuary power to promote a student. In the order passed by the President of West Bengal Board, there is no comment and or indication that the head of institution, whether by special reason to be recorded in writing, overruled the advice of the council, and it is stated that no action was taken in terms of Rule 33 of the management rules. It is stated further that there cannot be a practice for grant of promotion on the request of guardians. It is stated further that the incident relates to the year 1986, and it appears that one MB thus secured such and such. Then kindly turn the page. P11. An application was submitted by the husband of Rithika Singh before the Secretary of West Bengal Board of Secondary Education seeking certain information under the Right to Information Act, and pursuant to the application submitted by the husband of Bithika, it transpires that the State Public Information Officer submitted information and a copy of the information is annexed. My lord, I placed it. Kindly come to page 176 and 177. Particularly 178, my lord, kindly come to. I have placed this already. Paragraph 2 or clause 2 of that letter. The general norm of passing any student in any class in 1986 was that the student shall have to obtain pass marks in all subjects. However, in exceptional circumstances, results, that is, promotions, are generally discussed in the academic council, whose decision may be referred to the MC for consideration and final decision. My lord, it is nobody's case that, my lord, the MC did not take that decision. Now, kindly come back to the affidavit once again, page 155. Subparagraph 12 of paragraph 3. No decision of the managing committee of the school had been referred before the West Bengal Board of Secondary Education in respect of promotion of Srimati Taposhi. No decision of academic council was also placed before the West Bengal Board of Secondary Education in respect of promotion of Taposhi. Since no decision of academic council or the managing committee of the school had been taken, she cannot, my lord, she is not competent to say this. Page 155, subparagraph 12, 4 lines from the bottom. Since no decision of academic council or the managing committee of the school has been taken and was never placed before the West Bengal Board of Secondary Education, it cannot be contended that Taposhi had been promoted to class 8 from class 8 to class 9 by exercise of residuary power. Now, my lord, the promotion was granted. It is not in dispute that, my lord, the promotion could have been granted even after, my lord, the candidate did not obtain the requisite marks. There is no dispute about that. Now, the school had granted the promotion in 1986.
Yes.
Steps for, my lord, appointment in this post were taken, my lord, in 2006 after 20 years. The appointment took place in 2008. Inquiry was made in 2010. It is nobody's case, my lord, that the school committee was called upon to produce the decision of the managing committee. Bithika was there before the president. Hearing took place in her presence.
Did the school file any affidavit?
School, my lord, no, I don't think so. But school party chilo.
So your argument is, irrespective of having passed and failed, it is established that she was promoted. There is no dispute, and that promotion can be granted in terms of the norms would be evident from the order of the president. So question of calling for the academic council resolution or managing committee resolution is not required.
My lord, nobody, with respect, my lord, nobody said that this promotion granted was contrary to the managing committee's decision. The school was represented before the president. Taposhi, Bithika, and school, my lord, three were, my lord, there before the president. Now, it was nobody's case at that point of time that here the committee did not, the managing committee did not take this decision.
Now, this president's order was not challenged.
No.
School के तुम्हें resolution চলো ঘুরে আসি। We have heard Mr. Mitro, learned senior advocate. Sorry, 2 p.m.
Wednesday?
No, no,
Thursday.
2 p.m. Don't make it 2 p.m. Later we can reach it earlier because we have further feature. 2 p.m. টা কেটে দাও।
26.
26 করে দাও।
Gotcha.
Yes, কোথায়? Yes, Mr. Bag. They allege that you are.
I understand, my lord. Very wrong pictures painted. I'll indicate why, my lord. I'll give you 2 minutes. There was a conversion report which I had shown, my lord, at page 216. That was granted in
the new pond.
My lord. That was granted in the month of March. I'll indicate.
Bringing on record, my lord, what is happening?
That was in the month of March, my lord. From then, the work started. It is progressing at the same pace. There is no difference. From March, it was progressing, my lord. In the meantime, for a short period in April, my lord, when it was obstructed, we filed that, my lord, petition under 144. When there was an order, again, my lord, we started the work on the same pace. No difference, my lord. That it is not suddenly it has started. No, my lord. Started on the same pace again. After that order, again we were prevented.
New pond excavation.
No, my lord, new pond is over now. We have made that new pond. New pond is made in that 2 plots which we have, 416 and the other one, my lord, 413, and those 2 plots, it is over. The new pond is made. We have completed that.
Then when he kept it
Consequentially, my lord, when the new pond is made, we have to fill up this pond. That work is going on from March. Same pace, because we were obstructed, but we filed that petition under 144. After that order, again we proceeded.
It had fallen
So
from
it's
the
still
honorable
the
court.
same pace. It is
had
not
fallen
that
from-
suddenly something has happened and overnight we are working. That's the wrong
Enough of
submission to
crafty-
make.
Enough of crafty
That
submissions.
is
my
not
lord.
right, and that
Enough of crafty
submission should not
submissions,
have
my
been
lord.
made.
A fraud has been
So
perpetrated on the.
and that is being, my lord,
There is no
submitted
response
by
to the fraud, my
someone
lord.
who is a petitioner in the matter, in the appeal, my lord, where, my lord, my contention, and I'll come back. I also called the clients, my lord, I've taken specific instructions from them as to what is going on in the property, because, my lord, I have to take instruction. I took that instruction. They are here in court. If it falls from your lordships, my lord, that till the matter is heard on Thursday, do not proceed with any work, stop the work. Kindly don't record an order. I am giving an undertaking, we'll stop the work. But not kindly appreciate this. The difficulty is, we will do that. But not the, today the difficulty is, first, my lord, I'll argue on Thursday, and kindly permit me to argue that there's a 2025 judgment following the 2020 judgment, my lord, on person aggrieved. I will show from, my lord, the records that my learned friend cannot come and state that he's a person aggrieved, he has no interest in the matter. I'll show that. My lord, today the difficulty is, my lord, I will suffer an order at the instance, because today, my lord, anything happens.
We are not on that.
On the
We are
merits,
here-
I understand that.
Lord,
Look,
I have
today,
affirmed the
today, may I
submission
only
and
indicate
bringing
this?
on record, my lord, the photographs, my lord, enclosing, my lord, the Anandabajar Potrika, which was published yesterday, as to what was also being undergoing yesterday.
That's, my lord, what we have stated
To
in the
indicate, my lord, the status and how, my lord, attempts are being made, my lord, to overreach the powers of the honorable court. First of all, my lord, a fraud has
overreach
been,
the powers. I don't
fraud
understand,
has been
my lord,
it
this
had
submission.
specifically.
We have
it
not
had
done
specific-
anything which
it
is
had
which is
specifically
not
fallen, my
permitted
lord,
by law. I do not understand this submission.
Specifically
Wait,
fallen from,
Mr. Bhattacharya.
my lord.
Not record, but maybe.
Well, Mr. Bal.
Tomorrow, my lord, I'm in some difficulty tomorrow. I said that, my lord, that's why Thursday was, my lord, the date fixed.
So then your undertaking we have to record now. The file court is not, do not have the file today.
My lord, if your lordship wants to keep it tomorrow, my lord, I'll come tomorrow. Because, my lord, the only difficulty is, my lord, I'll suffer an order. I'm giving an undertaking, my lord, because that's the instruction I've taken. Today, if it is recorded, my lord, then it will be in the nature of an order against me in a petition, my lord, where we are challenging the locus of the petitioner.
No, no,
That's
Mr.
the
Bal,
difficulty.
we cannot record your undertaking.
I understand that, my lord. I understand that.
Because
Then,
the
my lord, kindly
file
keep
is
it tomorrow.
not recorded.
Well, kindly keep it tomorrow. We'll come tomorrow, my lord.
Construction, what is the state? Show any
But there,
picture.
yes, but this is the present status. I have managed photographs.
May I also have a copy, my lord? I'm not served with a copy.
I cannot serve unless and until the honorable.
I
court
understand
permits.
that.
That is the procedure. My lord, will find, my lord, I have annexed two photographs, pages 8 and 9. Page 8 is, my lord, what they were doing yesterday also. They were working, my lord, overnight also.
No, columns have been.
No, this is, my lord, they are feeding up the pond, the water body, my lord. The water body which is in question. They are feeding it up at a very fast pace.
From the
It
month
had-
of
it had-
March.
It had fallen
From
from,
the month of
it had
March.
fallen
I'm
from
sure
the
my
honorable
learned friend will
court.
indicate that.
It had fallen from the honorable court on that day that you lay your hands off till the 11th when the matter is next.
I do not.
Then my
I
learned friend
don't think I've
submitted.
heard that.
Then my learned friend.
Mr. Bagh, we accept your
My
argument
lord.
that you are undertaking, but because you are a council, we are accepting that.
I'm very
Otherwise,
grateful.
wouldn't have done.
I'm very
because
grateful, my lord.
I don't know. We do not know what happens in Thursday. Their allegation would be in between Monday to Thursday. Further steps.
I'll also indicate this, my lord. I've taken instruction as to how much time, because it's continuing from March.
We are not on that.
No, my
We
lord.
have kept it on Thursday.
My lord.
You have said that we will not do the work.
We will not, my lord. We will not. I'm indicating
But
that.
if it is mentioned before us again that you are doing the work, then we will be constrained to take appropriate.
May I indicate this, my lord? I'll indicate my helplessness. But today, if my learned friend comes tomorrow and makes the same allegation,
We have kept it on Thursday.
I understand that, my lord. Tomorrow, if they come and make the same allegation, my lord, when I've taken specific instruction, they will not construct. But if they come and, my lord, annex the same pictures and say that, look, It is again going on. That difficulty we are facing.
Alright, Mr. Bhattacharya.
We'll come back on Thursday, my lord.
Says, when the advocate says.
Officer of the court, my lord, is my lord.
Officer of this
yes.
court, so we don't.
I
find
will, my lord,
any-
I will go by my lord, what my, the submissions
so
of my
we,
learned brother is, my lord.
so how should we disbelieve our own officer?
Also, my lord, may I only indicate this? I've taken instruction how much time they will need to fill up this
We are
rest part.
not
It is
that.
2 months.
How much time
Right.
we
My
are
lord.
not, we are not that. When you have told us that they will not be doing with that work for 2 more days, don't do it. On Thursday, we pass our order.
Very,
for
very
hearing.
deeply obliged. My lord. Very deeply obliged. Deeply.
But may I
Let's
take
get
back
it.
the supplementary? Is it?
No, you keep it with you, give it on Thursday, and but if you want to use it, give a copy to
Yes,
Mr.
I have already, sir.
They have, sir. My learned friend has, sir.
Grateful to
Deeply
you.
obliged.
কোনটা মার্ক করব কোনটা দেখব
But I just wanted to know, my lord, if your lordships require any clarification. For that, I'm here. But Mr. Bandyopadhyay is supposed to start today.
তুমি আর করো না ভাই I have prepared a
Can there be an action replay? From which document?
I will be pressing from mat number 890 of 2023. But also your lordships take the convenience brief which has been made, which has been prepared in mat number 1873 of 2023. Also keep it. Otherwise, I am. If it is available, otherwise I can hand it over.
No, Mr. Dotto placed from 873, na? You placed.
Sure, কি বলছো yourself?
You placed from 873, na?
Yes, 873.
I'll be pressing from 890.
8?
Mat number 890 of 2023.
ওইটা রাখুন রেফার করলে আপনি দিয়ে দেবেন
No,
রাউন্ডের ইয়েতে আছে
কিসেরে
এয়ারড্রপে নিয়ে নেবে
কোনটা
90 যেটা
push.
এইটা এই কাকারটি কি বললো 890 বললো
List of dates and also along with the list of cases also, I am handing it over for so that the time will be very.
So you are appearing for the appellants in 890 and
890 of 2023. I am appearing for other appeals. Also there are, but
No,
I am arguing from 890.
No, you said you are appearing in 1873 also.
No. 1873, someone is appearing. They have made a compilation, that convenience brief that I have given it to you. But I will be relying. But I will be relying upon mainly from my papers. Kindly take note the list of dates. It will be very.
Yes, Mr.
My lord, 23rd August 2010, NCT published a notification in exercise of the powers conferred under Section 23, subsection 1 of the Right to Education Act 2009, thereby prescribing minimum qualification for recruitment as a teacher in class 1 to class 8. That's Millard 1 to 4 of the convenience 1873. Then Millard 12 November 12 November 2014. In exercise of the powers conferred under Section 332(2) DD, read with Section 12A of the NCT Act 1993, NCT published a notification
namely National Council of Teachers Education determination minimum qualification of persons to be recruited as education teacher and physical education, prescribing in primary, upper primary, secondary and secondary education so and so. Regulation 2. This regulation inter alia prescribe minimum academic and professional qualification required for being appointed as a primary teacher. Regulation 5 provides NCT the power to relax any of the provisions of the at the request of a concerned state government, save and except the regulation with regard to the minimum qualification for appointment of teachers for class 1 to class 8. This is very important for our case. Because point was taken by the one of the point that the repetitions that qualified, non-qualified, okay, trained and untrained. I will come to that. This is annexed phase 2 and so. 9th April 2015, Additional Secretary, Ministry of Human Resource and Development, Government of India, in exercise of the power conferred under Section 23, Subsection 2 of the Right to Education Act 2009, extended the relaxation to the state of West Bengal in respect of a minimum teacher qualification norms by the NCT till 31st March 2016. That your lordships kindly take volume 1, page 92.
Yes.
This is the 9th April 2015 letter, extension of relaxation to the state of West Bengal under Section 23, subsection 2 of the RT Act 2009 for the appointment of teachers up to 31st March 2016. Lordships kindly come to, I just go to the very relevant portion, kindly come to Milord, page 95 bottom. Now, therefore, in exercise of the power conferred by subsection 2(7), clause 7 of section 23 of RT Act, the central government hereby extend the relaxation to the state of West Bengal in respect of the minimum teachers qualification norms notified by the NCT as published in the Gazette of the India so and so 25th August 2020 in so far as they relates to class 1 to 8 as under 2 years, 1 year bachelor so and so. Important part is the aforementioned relaxation shall be valid up to 31st March 2016 and shall be subject to the following conditions, namely. Why I am showing, my lord, in this, unfortunately, the learned single judge has overlooked all the notification, and unfortunately, the board did not place all these documents before the learned trial court.
I didn't follow, Mr. Wanda. What you said now, therefore, clause
Relaxation has been granted up to 31st March 2016.
Where do we get it?
Page 96.
Yes.
Next, Miller, kindly come to list of dates. The relaxation were there. Then, Miller, 26 June 2015, West Bengal Board of Primary Education published an advertisement notifying the date of making application of TET 2014. It was further notified in the advertisement that a TET 2014 examination would be held on 30th August 2015.
Where you are reading?
List of dates, page.
List
page
of
3.
dates, which date?
Page 3, 26 June 2015.
26 June is not in our page.
Sorry, my lord, I am very sorry. Sorry, my lord. Sorry, that has been. Anyway, my lord, that's not there, I says. See, my lord, 14 July, this is not very relevant here. 14 July 2015.
What was the relaxation, Mr. Wanda?
Relaxation that the even you have a TET, you can appear in an examination, but you have to obtain the qualification of DLT, DLLT within a further within the period specified there. And Lord, that is the crux of the matter here. That is the crux of the matter. The learned single judge has not followed this. I will show. Learned single judge has stated, we are untrained, therefore we could not have applied.
Our application should not have been entertained. Our appointment, our selection was bad. I'm coming. I will make it very clear when I'll be pressing these documents.
So you are apropos Mr. Dotto, na?
No. The unfortunate part is
no. You are.
Yes. But additional. I used to clarify all that things.
Yes.
2nd March 2016. West Bengal primary school teachers recruitment rules were notified after considering all the objection. So and so. 14th September. TET result. That's our TET result have been declared. 14th September 2016. That is our TET result, and also the writ petitioner's TET results have been declared. Now, Millard, kindly come. 14th September 2016. This is very important, Millard. The Honorable High Court at Calcutta in WPA 14548W of 2016, Chinmoy Dolui and another versus Union of India, reported in 2016 SCC Online Calcutta 4960, permitted the state of West Bengal to appoint untrained candidates as assistant teachers in primary school even after the period of 31st March 2016. Paragraph 24(1), subparagraph of the word of judgment is good. The notification dated 1st April 2015 was in force up to 31st March 2016 within the said specified period, and the selection process would not be carried out due to the general election being published for the state assembly election. Under this circumstance, if this court permits the respondents in order to complete the selection process, the characteristics and objects of the students will not be jeopardized. The judgment and order for service, this has not been appealed against. Then, Millard, this is important. Millard, West Bengal Board of Primary Education read a memo number so and so. Invite applications. And let me take your lordships to the advertisement itself. Kindly come to page 117 and 118 of my paper book. Millard, kindly take these 2 copies, maybe not legible. Kindly see. This is very important for our case. And this is the point. Exactly, this is the point have been missed by the learned single judge. 170. May I read?
Yes.
In continuation of our notice number so and so dated 24th September 2016, this is notified further to all concerned that online applications are invited from TET 2004 for qualified candidates of West Bengal seeking appointment to the post of assistant teachers of a particular council only in the government-aided sponsored primary junior basic school under the district primary school council primary school to the 42,949 vacancy. Can you see the mark the vacancy? As mentioned below, the selection and appointment of the candidates will be made in terms of the West Bengal Primary Teachers Education Rules 2016 as amended up to so and so. Now, let qualification part. The citizens of India on such other nomination as are declared eligible for government of India has completed the age of 18 years as on 1st day of January of the year of advertisement and has not completed the age of 40 years on the 1st day of January and of the year of advertisement, higher secondary so and so, graduation, irrespective of the marks obtained therein with at least 50% marks and and 2-year diploma in elementary education by whatever name known and qualified TET ability to read. Therefore, this part is showing that the qualification and 2 years diploma in elementary education. Then kindly read note 1. The persons qualified TET and having qualification of higher secondary pass under the West Bengal Council with at least 50% marks or graduate irrespective of marks obtained therein without 2-year, can you read it? Without 2-year diploma in elementary education by whatever never known in accordance with the National Council for Teachers so and so are also eligible to apply for appointment of primary school teacher in the state subject to condition that those who will be appointed without professional qualification shall acquire the professional qualification within a period of 2 years from the year of appointment. Well, this is a very important part of this matter. And that this argument, Milord, if I am right, this argument will establishes the judgment, reasoning of the judgment of the learned single judge was contrary to the Milord, the advertisement notice itself. What it speaks about, The relaxation, if you don't have the 2 years, this diploma in elementary education, you can make an application. If you make an application and you are appointed, well, this is very important word, if you are appointed. If you are appointed, you are giving a chance to complete the course within 2 years.
Yes.
Distinction in this case is, my lord,
yes,
we were not having the 2 years diploma course at the relevant point of time when the application was made. Neither we were not the petitioners, right? But we were appointed.
On the basis of such relaxation.
On the basis of
such
no relaxation, we were appointed with a condition 2 years have been that we have fulfilled. I will show to it. But they were not appointed. Therefore, they were not entitled to be enjoyed this clause.
Yes.
This is a basic distinction of the matter itself. The learned single judge has gone on a reading that all are persons are not 2 years course are having, therefore they are disqualified. But the note 1 speaks that those who are appointed, they will get the chance to complete it within 2 years.
Yes.
But not in their cases it is applicable because they were not appointed. Then Millard kindly come. 30th September 2016 to 7th October, that the applicants sharing the read period so and so more than 1 lakh intending candidates made applications pursuant to the said notification dated 26th September. My lord, কোনটা পড়ছিল page 5 তো না কোনটা?
Yes, 30th September. 26th September.
30th September 9.
Yes.
That the applicant sharing the read petition respondent number 1 to 140 and more than 1 lakh intending candidates made application pursuant to the said notification dated 26 September 2016 for appointments to the post of assistant teachers in primary school. The present appellants respondent 1 to so and so and other nearly 1 lakh applicants at the time of making the application were untrained. I am reading from the here because all these averments in the all these petitions are there. I am not taking that time, Miller. Then 12th October 2016, West Bengal Board of Primary Education notified that the scrutiny verification of testimonials and viva-voce interview and aptitude test in connection with 2016 selection process would be undertaken between 19th October 2016 to 28th October 2016. It was notified that the date, time and venue of scrutiny and verification of testimonials and viva-voce interview and aptitude test of a particular district, my lord, keep your lordships kindly note it. Kindly mark it and note it.
Yes.
This is a very important thing, district-wise selection, not West Bengal basis selection, where the learned single judge has gone. District-wise selection. Website of and the candidates will also be notified about such details through SMS and emails. The applicants therein called for scrutiny, verification, and interviews aptitude test to be conducted by the West Bengal Primary Education on different dates at different places. I have given the annex here. Some examples I have given. Shall I show to you lordships or that's not required? Then Miller kindly February 2017. Applicants were given appointment as assistant teacher on probation for 2 years from the date of joining by their respective district primary council. Kindly similar everywhere, respective primary council, district-wise primary council. Respective primary council, district-wise primary council. Now, it was mentioned in the said appointment letters of the petitioners that their service will be regulated by the relevant government rules, so and so, subject to verification of the credentials. Annexed Swan Millard, annexed it is annexed there. I am not reading Millard, I am just Swan reading. Now, Millard, 31st August 2016. This I will take your to lordships, Millard. Earlier, I have shown to your lordships one relaxation. Now, kindly see, this is the relaxation is applicable in our case, Millard. That is at Millard volume 3 at page 663 to 666 of the paper book. These are the points, these are the circulars I have missed. 3rd August 2017, 663. My lord has got it. Volume 3, my lord. Volume 3 take to the just okay.
Yes.
My lord, 663 kindly come. This is regarding training of untrained in service elementary teachers in the government aided so and so private. It applies that the amendments to so and so of the RTF to extend the period for such training to 31st March 2019 has been passed by the parliament. Therefore, this is not pure, my lord, by the administrative order or notification, but by reason of an amendment in the act itself passed by the parliament. Now, my lord, kindly see. 3. A board strategy to complete the training of all such in-service untrained teachers by 31st March 2019 is proposed by MHRD. The following action is required to be initiated urgently at your end. 1, 2, 3. Kindly come to Milord, page 665. Page 665. The timelines along with the key milestones to ensure that the training of in-service untrained teachers is completed by 31st March 2019 are detailed in the table below. Therefore, today, Milord, that time, kindly see, these untrained service teachers who are appointed, they were statutory right has been given to them to complete training within 31st March 2019. Not by an administrative order, not by anything. By amendment of the act itself by the parliament.
Amendment to which act? This is
Can you kindly see this at the top?
RTI.
Yes, right to Education Act. These are because of Right to Education Act. Section 23, no? Section 23, subsection 2.
Yes.
Now, on that day, I know when the act was passed, I made my debate on that, why it was necessary. 665, 4.
No, this was on 3rd August 2017.
3rd August 2017. By that, it has been extended up to 31st March 2009.
Now, you placed before us this note 1. That is, you just now placed before us note 1.
Yes, note 1, kindly see.
That 2 years.
2 years.
That is 2016 memo.
No, appointment, from the date of appointment.
Oh, from the date of appointment. That was in 17.
17.
2 years.
19.
Now, this Right to Education Act, that is being referred to in this notification, which
yes, this notification because of the amendment of the see page 663.
600. No, this notification.
No. It is not there. I am telling about the laws.
Yes.
I am telling about the laws. Effectively, my lord, when this notification was made, that time, my lord, earlier notification was there.
Now, are they disputing that you were not entitled to this relaxation? Is the court saying that you were not?
Court is saying.
Court has what finding has been?
Court has given. I will show to you. Yes. Take it from me now. Court has said they are untrained. We are also untrained.
Yes.
We are not qualified.
Both the groups are untrained. When they have been given, you have not been given. You have been ousted on the basis of a faulty aptitude test. This was the reason.
This is the case. Therefore, I have given because I was appointed.
On the ground of relaxation, it was not turned down.
The court has not taken note of the relaxation even. Court has not taken the note of the condition of the advertisement even. All right, all right. My point is the learned single judge has not taken note of the advertisement.
Yes.
Learned single judge has not taken note of any of the notification.
Yes.
Let me put the point in this way. Learned trial single judge has committed an error by not applying his mind that even an untrained teacher, untrained person can make an application, and if he is appointed within 2 years, he has to get the. This is the distance.
You will show us when you come to the order. Yes. Now.
This part has gone, Millard, 2019. Done, Millard. March 2019, come to 14.
March 2000.
Appellants appeared in the examination of the second term of their diploma in elementary education. By 31st March, I have applied, exercise. Results have come later. Appellants received the final mark sheet and certificates after 22nd May 2019. November 2019, appellants, upon completion of the DLED course, were granted the training benefits by their respective district primary school. Appellants' pay category was changed from the B category scale to the A category scale. The moment I got this qualification, I am entitled to get the higher grade, and I was given to that grade. Kindly come to Millard, page 647, volume 3. My Lord Justice Chakraborty, kindly remember that there are so many litigations were there in the education group that we have become trained, our benefits have not given, court has passed so many orders. 647. See, the following 18 teachers of so kindly see, my Lord. This is the West Circle under Hooghly district. I said about district. Primary School Council have completed 2 years DLD course on 1 year PD 6 months special in service training. Hence, the training benefit is hereby allowed in favor of them. Here, serial number 4 is one of the appellant here.
Yes.
After completion, I have got it. Then, Millard, December 2019, serial number 17.
Yes.
After satisfactory completion of 2 years service, the service of the appellants were confirmed by their respective district primary school council with effect from 2 years after their respective dates of joining. But this is also in the therefore, Millard, appointment probationary, obtaining DLED course, then training, then Millard confirmation up to 2019. No one is aware about this.
Yes.
2016 selection, 2017 appointment, 2018, 2019, permanent confirmation, everything. No one is aware.
That is why you are here.
No.
Yes.
Millard, I am coming to an argument. Possibly your lordships are not required to hear the petitions at all. Set aside and send it back. Wait for a few minutes. Set aside this judgment and send it back to the single judge to hear the matter again. In complete violation of a natural justice, I will show to that.
Yes, yes.
May not be your lordships are required to take so much.
Yes.
If it is appealed to your lordships.
Yes, Mr.
Now, after satisfactory to a Swandamula conference, now come 10 December 2019, a batch of writ petition.
Yes.
A batch of writ petition of Swanso versus State of West Bengal are reported were moved before the learned single judge of the Calcutta High Court, challenging the 2016 selection process, same selection process, on several grounds. The Honorable Justice O.D. Banerjee dismissed the said writ petition on the grounds of delay, laches, and also held that since successful candidates like the appellants herein were not made parties in the writ petitioners, Therefore, in the absence of successful candidates, re-writ petitions cannot be heard at the distant date, and the selection of 2016 cannot be disturbed. I will read the judgment later on. Just keep it your lordship's mind that the first in 2009 selection process which were challenged by the batch of the writ petitioners were dismissed on 2 counts. One of the count delay, another count is not made parties. Now today, why my first forum has gone? You have not made me party in the writ petition. I have to come to live to appeal. Went to Supreme Court has set aside the order and send it to back.
That is there in this list of dates, Mr.
Pardon me?
That is there in this list of dates. Ultimately, you preferred special leave petition.
Not against this order.
You preferred special leave petition against the order.
Order passed in this proceeding, your proceeding which is pending before your lordships.
Please tell us on which date you went to.
I will show. Well, Supreme Court I will show. Now, therefore, first lordship kindly see.
Delay, non-addition of party, relaxation. Got it. Now, next.
Now, therefore, kindly just one of the judge has delivered a judgment.
Yes. It was shown to us.
Was it binding to the coordinate bench?
Was it placed?
Placed or not placed? I was not party. I was not party. Whether the board has placed it or not placed. If huh? Okay. No. Single bench এর কাছে কিসের উপর প্লেস করি না I have been told the learned advocate general appeared before the single judge and placed the judgment of Justice Orijit Banerjee. But unfortunately, the learned single judge has not not a single judgment has been recorded and said these are the niceties of the law. I am not required to go to the niceties of the law.
Yes, that has. We have seen that, Mr. Yes.
Our first judgment. I will read it the judgment later. Next. 12th September 2023. WPA 21187-2022 was filed inter alia praying for the disclosure of marks obtained by non-trained candidates and praying for the recruitment of the writ petitioner. The writ petitioner did not seek cancellation of the appointment of the successful candidate appointment, appellants nor any successful candidate. This is the writ petition, which your lordships and appeal your lordship is hearing. Therefore, 2017 to 2022, one of the single judge has dismissed. You are coming in 2022 without disclosing the single judge has dismissed.
Yes.
And if I am right, I will check it up whether some of the counsels were common.
Yes.
Therefore, my appointments have not been challenged in the writ petition at all. Next, 28 November 2022, in compliance with the order date 27 passed, the West Bengal Board of Primary uploaded the breakup scores of the TET 2014 qualified independent candidate against so-and-so. But kindly pause for a moment here. Just wait. Pause for a moment. Since we are not parties in the writ petition, we could not able to take the point the petition was not maintainable.
Yes.
If an illegality is in the trial, that cannot be cured in an appeal.
Yes.
In a case of a natural justice, I'll show the judgment. Therefore, today, first point has to be decided whether that writ petition was entertainable.
Yes.
After having such a delay, and when the Justice Orijit Banerjee's judgment was there, we don't go by emotion, we go by law. And law prevails over the equity. Law prevails over everything. Law is blind, one has to follow the law. No emotion, no perception, nothing. Whatever the law, one has to decide, we have to consider, decide the cases on the basis of the law.
Yes.
Next, Miller. In comparison with so-and-so, 12 May 2023, WP so-and-so was allowed by the learned single judge with an impugned judgment order without even considering the judgment dated 10th December 2019 and the judgment dated 23rd May delivered by the 23rd March. Also a judgment was delivered before 12 May. Sorry, that was a judgment of Justice Hiranmoy Bhattacharya. I will show. Justice Hiranmoy Bhattacharya also dismissed a writ petition, batch of writ petitions. Point of argument as well.
Yes.
23rd, I will show to the lordships when I will cite the judgment. Therefore, before
I got it.
disposal of this writ petition, there are two coordinate bench judgments.
Yes.
Next, my lord. My lord, directions of the judgment. By this time, your lordships know about what are the directions. I am not required to read. When I will read the judgments, I will read it. I am not wasting your lordships. I am trying to do it so quickly as that possible, my lord. Then, my lord, kindly come to page 11. The appellants prefers a latest patent appeal before the Honorable High Court at Calcutta. That is, this is the appeal. So-and-so, and an application for leave to file a so-and-so, memo of appeal so-and-so. 19 May 2023, the appeal court passed an order. This is the order, my lord. Appeal court passed an order. At page, your lordships will find 695 of volume 3. In this appeal, my lord got it, page 695, kindly see.
Yes.
695, my lord, big judgment. And kindly come to my lord, ordering portion. 715.
Hmm.
715. 1, 2, 3, 4 paragraph. Having heard the parties, the closely considering the materials placed, this court finds as follows. That admittedly the writ petitioner accrued a cause of action with the discovery of fresh materials placed by the board on 28 2022. As a consequence that the Honorable Single Bench was within jury to inquire into the aspects connected to the discovery of fresh materials. At the same time, the Honorable Single Judge had a duty to extend a right of hearing even in representative capacity to the present appointees, that is the appellants. This duty became manifest in the context of the appellants being protected from the loss of their job being the consequence of the decision rendered by two earlier concurrent honorable single benches of this court. This court intends to record the niceties of law relating to grant of naturalization, accrual right, delay and waiver, burden of proof, presence and value of decision. They have a role to play in maintaining the system of adversarial litigation adopted by our courts unless hopelessly excluded. It is true that justice delayed is justice denied, and conversely, justice hurried is justice worried. To the mind of this court, therefore, the termination of job otherwise protected by two earlier orders of the Colonel of so-and-so, without extending a meaningful right of defense to the affected parties, prima facie requires judicial intervention. At this stage, this court is also required to notice the proposition that the alleged complicity of the candidates in the commission of the alleged fraud rather deeper, leaving the issue thereafter to the court to strike down all fraudulent action. Accordingly, there shall be an interim stay on termination of jobs till the end of September 2023 or until further whichever earlier. However, the board shall conduct the selection exercise exactly as directed by the Honorable Single Bench within a period of 3 months by and within the end of August 2023. The matter shall appear before the appropriate bench division in the first week of September 2023, subject to convenience. Therefore, my lord, this judgment, this order shows. Prima facie, your lordships have been observed. We should have been given an opportunity of hearing by the learned single judge.
Yes.
And especially in view of the two coordinate benches judgment. Termination order was stayed, but the selection process. Against that order, we preferred the SLP. That SLP, your lordships was asking me, will not kindly come to next page 718. It starts from 718.
Yes.
Kindly come, Millard, page 720. Permission to file special leave petition is granted. Issue notice. Notice is accepted by the respective respondents appearing on caveat. By consent of the parties, the instant petitions are heard and disposed of. These special leave petitions arise out on an order dated 19 May 2012, passed in MEMT number so and so, passed by the division bench of the Calcutta High Court, passed by the learned single judge in WPS so and so. The original writ petitioners have assailed the recruitment process of assistant teachers conducted by board in furtherance of West Bengal Board of Primary Schools. The direction as spread before the learned single judge was against the concerned authorities to disclose the names, number, and category. All those candidates recruited till the date of filing of the writ petition in primary schools in the state. It was also prayed that the original writ petitioners be equally treated at par with those candidates who have already been recruited by the board, and they be granted the same benefits as extended to teachers already recruited in terms of the aforesaid rules. It was further prayed that they may be treated as par with non-trained candidates recruited by board after expiry of relaxation given by MHRD in the year 2015, and directions be issued to concerned authorities to issue the merit list maintaining transparency. It was in this connection of the original writ petition before writ court that they were qualified intelligent and despite having participated in the process selection, they were denied appointment. Thus, claiming parity with the various other candidates who were appointed following the recruitment process, the aforesaid reliefs were prayed for. The learned single judge video order is so and so, passed in so and so, directed by the council so and so. The order has been set out. Now, kindly come to page 723. Assailing the aforesaid order, the learned counsel for the appellant incumbent employees submitted before the writ appellate court that the directions as issued by the learned single judge are in gross violation of the principles of natural justice. Since the same has been passed without joining the affected person as a party in person or in representative capacity being a necessary party, and without affording opportunity of hearing to them as per the averments made in the writ petition, cogent allegations for establishing fraud in the selection process were not alleged. And in spite of that, the learned single judge directed for holding the fresh selection while cancelling the appointments of the more than 30,000 teachers, including the petitioner's hearing. The division bench of the High Court of Calcutta by the impugned interim order found that the termination of jobs as directed by the learned single judge prima facie required judicial intervention. The division bench granted interim stay on the termination of jobs till the end of September 2023 or until further orders whichever result here. In the said interim order, it was observed by the division bench that considering the alleged complicity of the candidates in the commission of fraud in the process of selection which is contended surfaced during the pendency of the writ petition, it required deeper scrutiny in the scrutiny by the court. Therefore, the court also observed as under court. The court has directed to list the case before appropriate division bench in the first week of September 2023. Being agreed by the said direction, these special leave petitions have been filed. The primary contention advanced before this court is that the process of selection has been set at naught by learned single judge without joining the petitioners herein as parties to the proceedings and affording them an opportunity. It is further contended that having found force in the said contention, the order of termination was stayed by the division bench. However, it is contended that the conduct of fresh selection of more than 30,000 teachers in a time-bound manner has been continued despite foundation of fraud being not on record. Kindly mark it. Foundation of fraud being not on record in pleadings and more so without affording any opportunity to the affected person to defend the case, which is in gross violation of the principle of justice. Sri Joydeep Gupta, learned senior counsel appearing for the board while supporting the contention of the petitioner hearing, urged that the holding fresh interviews is a cumbersome and expensive exercise which cannot be possibly done as directed by an interim order. On the other hand, learned counsel representing original writ petition defended the order of the learned single judge, containing that once the process of selection has been found at fault and the termination of petitioner has been stayed by interim order of the High Court. The continuation of fresh selection as by so-and-so court does not warrant interference by them. Having heard learned counsel for the High at length, and considering the fact that the order impugned passed by the division bench is interim in measure, we refrain ourselves from expressing any opinion on the merit of the case. At present, we are prima facie impressed with the contention of the petitioner herein that the order passed by the learned single judge was without joining them as party and without hearing them even in a representative capacity, though they were working since more than 5 years. The division bench video interim judgment order found weight in the contention, but only stayed the termination of service and did not stay the selection process, which was directed to be conducted following the cancellation of the arrest appointment. We find a reasonable force in the submission made by the counsel for the petitioner that if the appeal which is sub judice before division bench succeeds, then the whole colossal task of conducting and continuing with the selection process will go absolutely in vain and lead to enormous financial burden on the board. Therefore, in view of the aforesaid, we set aside the impugned order of division bench to the context of the issuance of the direction to conduct the selection appraise. The said order is subject to final outcome of the orders in the matters pending adjudication so-and-so. At the cost of the repetition, we further make it clear that we have not expressed any opinion so-and-so, so-and-so. Therefore, why set aside? We have not made parties. Today also I am saying, my lord, the learned single judge judgment should be set aside because we have not heard.
Yes.
Well, on 2 counts, I will say that this order is required to be struck down. This order is required to be struck down for not getting a chance of hearing for 2 reasons. One of the reasons we are not heard. Second most important reason is this. The learned single judge has relied upon the evidence of different witnesses. Did I get the opportunity to cross-examine them?
Yes.
I have not got the chance to cross-examine them. Firstly, if the matter was not to be heard without hearing the affected parties, is a right proposition of law. Is a right proposition of law. Then secondly, whether an evidence can be relied upon without giving me a chance to cross-examine them.
Yes, yes.
Therefore, both the 2 counts, this judgment is alone to be required to be set aside.
Yes.
Whether board has examined or not examined, what are the board's intention, board choice, I am not concerned about it. I have not got any sympathy from the board, rather petitioners have got sympathy before the learned single judge from the board itself.
Yes.
Not a single point has been raised before the single judge. At the very first day, when the petition was moved, board was supposed to take the point of the maintainability. Or board should have said that the appropriate, the persons who are affected, they should be made parties. At whose interest the board have not done it.
Yes. Yes.
I will show, Millard, one thing. I will come to the next I will show just judgments. But judgments. But one of the important judgment I want to show your lordship. Institute of Chartered Account.
Impugned order to place.
Institute of impugned order, I will place the impugned order after submission of my judgments.
That has been extensively placed, Mr. Bandowad.
Some points I will just, not that entire judgment, some points, somewhere, some places I Joseph Kedar. This judgment was not there in the compilation. I have given the compilation. Bear me.
We are hearing you, Mr. Bandowad.
Huh?
We are hearing you, Mr.
No, just judgments are there. I have made it very short for, I know your lordship. The way your lordship works, I know. I have made it. Kindly come to 1986, 4 SCC 537. Kindly come to para 17 at page 552. Case is Institute of Chartered Accountants of India versus L.K. Ratna and others. Kindly come to Milord, paragraph 17. First, kindly come to paragraph 17. 17. It is then asked by the learned counsel for the appellant that the provision of an appeal under section 28A of the Act is a complete safeguard against any insufficiency in the original proceeding before the council, and it is not mandatory the members should be heard by the council before it proceeds to record its finding. Section 22A of the Act entails so and no limitation has been imposed on so. Such a learned counsel appearing has in mind that view taken in some cases that an appeal provide. No, learned counsel apparently has in mind that the view taken in the case that an appeal provides an adequate remedy for a defect in procedure during the original proceeding. Some of them cases as mentioned by in Sir William Wade's erudite and classic work on an administrative law 5th edition. But as the learned author observes, in principles there ought to be an observance of the natural justice equally in both stages. If natural justice is violated at the first stage, the right of appeal is not so much as a true right of appeal as a corrected initial hearing instead of fair trial followed by an appeal. The procedure is reduced to an unfair trial followed by the fair trial. And if the makes the observation, Major J in Leave National Union was vehicle builders, treating with another aspect of the point. If one aspect the contention that a defect of natural justice in the trial body can be cured by the presence of natural justice in the appellate body, this has the result of depriving the member of his right of appeal from the expelling body. If the rules and of law combines to give the member of the right to a fair trial and the right of appeal, why should he be told that he ought to be satisfied with an unjust trial and a fair appeal? Even if the appeal is treated as a hearing of de novo, the member is being stripped of his right to appeal to another body from the effective decision to expel him. I cannot think that natural justice is satisfied by a process whereby an unfair trial, though not resulted in a valid expulsion, will nevertheless have the effect of depriving member of his right of appeal when a valid decision to expel him is subsequently made. Such a deprivation would be powerful result to be achieved by what in law is a mere nullity, and it is no more triviality that might be justified on the ground that natural justice does not mean perfect justice. As a general rule, at all events, I hold that failure of natural justice in the trial body cannot be cured by a sufficiency of the natural justice in the appellate body. Therefore, today, if there is a violation of natural justice in the trial court, this judgment is needed to be set aside alone on that ground.
Yes.
Which is, if I had an unfair trial, if I have not heard it there, my lord, with great respect to your lordships, my lord, in an appeal court, your lordships cannot correct that. If it is sent back, a judgment comes, again I will get a forum of appeal. I cannot be deprived of a forum of appeal.
Yes.
And two important counts I have given. Not heard, not cross-examined. Not heard, not cross-examined. Now, my lord, take my compilation. Joseph ke dao. No, so all pages I will not read. Only few paragraphs. Well, kindly come to me at page 1, first of the compilation. 2010, 12 SCC 204. Kindly come to paragraph 9 and 10. Page 4 and 5.
Yes.
Kindly come to paragraph 9. In case respondent 1 wanted her selection against the reserved category vacancy, the last selected candidate in that category was a necessary party, and without impeding her, the petition could not have been entertained by the High Court in view of the law laid down by nearly constitutional bench of this court in Udit Naran Singh so and so, wherein the court has explained the distinction between a necessary party, proper party, and pro forma party, and further held that if a person who is likely to suffer from the order of the court and has not been implemented as a party has a right to ignore the said order as it has been passed in violation of the principles of natural justice. More so provided also and so that they provide the non-joinder of nation party be fatal. Undoubtedly, provision of CPC are not applicable in this jurisdiction by virtue of the provision of section 141 CPC, but the principles enshrined therein are applicable. In Prabodh Bharma versus State of West Bengal and Tridip Kumar Dangal so and so, it has been held that if a person challenges the selection process, successful candidates or at least some of them are necessary parties.
Yes.
Then Miller, next case, 2014 volume 16 SCC page 187.
Para?
187 paramiller 10, 11, 12, 13. Kindly come to page 7.
Yes.
Malad,
on the same point.
Same proposition, but I just this is now the last one. Malad, kindly, I will not read paragraph page 11. Kindly mark Miller paragraph 10. Paragraph 10 to 13. 10 to 13, kindly mark it. Ten to 13.
13 to 2.
I will just read paragraph 13, nothing more, 3 lines. In view of the aforesaid enunciation of law, we are disposed to think that in such a case, when all the appointees were not imputed, the writ petition was defective and no relief would have been granted. They were today by your lordship division bench. Writ petition has been disposed of. Appeal your lordships are hearing. Today your lordships will set aside the order and dismiss the writ petition. The appointees are not been made parties.
Yes.
Now, Milord, I am switching Milord on second point. The lordships will find from the note my page 13.2. Honorable single judge ignored the binding precedent of the coordinate bench. Lordships have seen that. Now I will show to you similar Justice Banerjee's judgment in this matter.
Page 70.
Page
70.
70.
Citation to Korean.
2019 SCC online Calcutta 4324. We are making so much research. The learned single judge should have also made so much research. iPad is given, SCC is given, will not check it up whether the High Court has passed a judgment or not. 2019 SCC online Calcutta 4324. Kindly come to Miller paragraph 14. See what have been dealt with by the Justice Banerjee. The petitioners have challenged the, Miller got it? The petitioners have challenged the process of selection of candidates for appointment of the post of primary teacher in schools under different DPSs. If the petitioners succeed in establishing that there were incurable infirmity in the recruitment process, the entire process along with the panel of successful candidates prepared pursuant thereto will have to be set aside. I have given my anxious consideration to the rival contention advanced on behalf of the respective parties. I am unable to allow the writ petition for reasons more than one. Firstly, it is not in dispute that pursuant to the selection process that was initiated by issuance of notification date 2016, a panel of successful candidates was prepared and appointments have been given to a huge number of candidates in post of primary school teachers under different DPSs. If the petitioner pair is allowed, the appointment of such candidates will have to be set aside. In other words, such candidates would be badly affected if an order is passed as paid for by the petitioners. This makes such candidates necessary parties to the instant writ application. Any person who may be adversely affected by an order which may be passed in a legal proceeding is a necessary party to such proceeding. Without hearing him, no effective order can be passed. An order passed without hearing necessary party is a nullity and has no binding effect. In this connection, one may be referred to the decision of the so-and-so. Another Supreme Court judgment has been referred. Now, your lordships kindly come to paragraph 20. The petitioners contended that a large number of candidates were given appointments and it was practically impossible to include all of them as respondents in the writ petition. This is not acceptable explanation. The petitioner could have and should have included a few of the candidates who were appointed. In representative, Rule 12 of the rules governing the application on Article 2 of the Constitution framed by this court contemplates institution of a writ petition in the respective category of the court framed by the court. A petition may be instituted a writ petition seeking to decide other persons also, according to him, would be similarly interested in the subject matter. And result of the writ petition, similarly, a petitioner may impede a person as a respondent in a representative capacity to represent the interest of others who may be similarly situated as the impeded as respondents. Further, Rule 53 of the state rules provide under the provision of the Code of the will apply to applications under Article 50 of the Constitution so far as the same can be made applicable. Order 1 rule of so and so for institution of suits and so and so are attracted to the writ petition for instance instituting a writ petition in a writ petition capacity. The petitioner needs to obtain leave of the court. No such prayer was made by the petitioner in the present case. Not such leave was obtained. Otherwise, a few of the appointed candidates have been included as respondents and not in a respective capacity, but in their individual capacity. Hence, the writ petition must fall for non-joinder of necessary party. Secondly, the primary ground of the challenge of the selection process is the smaller kindly market. Rule 8 for the recruitment has been violated in preparing the panel of successful candidates. Apart from such body, no material petitions have been filed in support of such, nor any documentary evidence has been disclosed in support of such. Copies of the document enclosed to the writ do not inspire credence and in any way do not advance the case run by the petitioner. In that affidavit of a filed on behalf of the West Bengal Board, it has been explained as to how Rule 8 and so rules has been scrupulously adhered to, and learned senior counsel appearing for the board has also explained the same to me in course of a submission. The petitioners wanted the court to direct the board to produce the entire record pertaining to the selection process. I was not and am not inclined to do so. The records are voluminous. It would practically be impossible task for the writ court to delve into such records and ascertain as to whether or not the panel under challenge has been prepared, violating the recruitment rules. This would entail adjudication of a highly disputed question of fact, which the writ court is ill-equipped to do. What the learned judge has done.
Yes.
In this case, next 22. It is not in doubt that the High Court will exercise the power of judicial can issue a writ of successor. This is paragraph 22, 23, 24. This is the judgment. I am not reading the entire thing to end. Next judgment. That is Justice Hiranmoy Bhattacharya's judgment, page 77. Your lordships kindly come. Two different coordinate benches judgment. Kindly do not mind, my lord. With respect, I will tell your lordships. From 2016, so many judges were there. They were sitting, my lord. Justice Mousumi Bhattacharya was sitting. Justice Banerjee was sitting. Justice Hiranmoy Bhattacharya is sitting. Other judges were sitting. Nowhere they have gone. Went to this court. Is it not forum shopping? Was it not a forum shopping?
Yes.
When you have felt convenience, then you have gone to that court particularly. Felt convenient. Then page 77. Felt convenient.
Yes. Yes, 77 on same lines it was.
No. Dismissed it, but on different grounds have been taken. Unfortunately, I have to say.
Paragraph?
Unfortunately, I have to say, the recently very Chief Justice of India has delivered a speech and said, it is unfortunate in our country, the sitting judge resigning and joining political party.
My lord, Mr. Banerjee, why we are going into these issues? Let us stick to the facts.
No, yes. That is a part of that.
Please, Mr. Banerjee. Yes.
That is the forum shopping. Then, Miller, this cited 2023 SCC online Calcutta 710.
Yes, we are on that judgment.
Kindly come to paragraph 9 to 24. You are saying, my lord, to me.
9 to 14.
9 to 24. If I give you one in see, my lord, page 17, paragraph 9. It is not in dispute. It is not in dispute that the selection process initiated with a notification of the board dated 26 September 2000 got culminated by giving appointment to a large number of candidates in the post of primary school teachers under different DPSCs throughout the state. The writ petitioners have sought for setting aside the entire selection process and for preparation of a panel in accordance with the reservation policy. In a writ petition, while the process of selection has been challenged and since a large number of candidates have been appointed, pursuant to the said selection process, this court is of the considered view. The right stood vested upon the candidates who have already been appointed, and such appointed candidates are necessary parties to the writ petition, and there is every possibility that the rights may be adversely affected. After going through the reasons of the Manik Das, kindly see. Manik Das means just Origin Banerjee's judgment. Of this court finds that the self-same selection process was also under challenge in the writ petition, which were decided by the coordinate bench, and more or less identical issues were raised therein. Then the coordinate bench, whatever held, it has been written, quoted at paragraph 11. I am not pressing. Kindly come to press, not pressing, I am not reading, pressing, yes, but not reading. And paragraph 12. Upon consideration of the writ petition, this court finds that the appointed candidates were neither implicated in their individual capacity nor in individual capacity. Leave to institute the writ petition was also not sought for. Therefore, the aforesaid finding of the court is squarely applicable. The court accordingly holds that the writ petition must fail for non-joint and necessary parties. The writ petition have made bold allegation that the reservation policy was not followed. Same thing has been done here.
Yes.
Delay so and so. However, the learned counsel for the writ petition has failed to demonstrate as to how the reservation policy was violated. The principal ground for challenging selection process, paragraph 14, 15, 16, kindly see. Justice Bhattacharya has dealt with each and every submission which have been made before justice. They had the learned single judge. We were the learned single judge. Something has happened somewhere in the air.
Yes.
See? Well, kindly see 15. I am not reading. Kindly mark it below when paragraph 19 is where the petitions have failed to demonstrate how to their legal right has been infringed while conducting the selection process by the concerned authorities. It has been alleged that there were irregularities in preparation of the panel, which is the subject matter of this writ petition. When the writ petition have alleged irregularities in the preparation of the panel in question, it is for them to prove such allegation by production of sufficient materials before the court to support their case as the relevant materials. What are the materials have been placed here? Whose responsibility, my lord? Responsibility of the petitioners? Here in this case, court has taken the responsibility on his shoulder. One of the presiding judge of this court in the these are the paragraphs 23, 24. I am relying, Millard. I have given in my note itself. You can read it. I have given in my note itself.
Paragraphs you have given?
I have given, Millard. So that I know, Millard,
yes,
we have lost this works, Millard. And that is very, it is also.
Yes, Mr. Next.
Joy Malla judgment. One of the judgment I am showing, very recent judgment. Renuka, this is not in the compilation, I am giving it to you.
What is the citation, Mr.
2025 SCC online, SC 970. Renuka versus State of Karnataka and another. 25. This is the judgment has been delivered by my Lord Justice Jayamallo Bakshi. Wait down. One paragraph.
17.
My Lord, kindly come to paragraph 17.
Seventeen.
Finally, it is argued there are cases and counter cases, and proceedings against parents-in-law have been squashed by the coordinate bench, noting in the parents-in-laws as a spectacular, and there is no whisper in the FIR that this test so and so. That's not very important. Kindly come to me few lines after. It was incumbent on the judge, while quashing the proceeding against the respondent husband, to refer to the earlier decisions of the coordinate bench and distinguish the reasons therein to arrive at a different conclusion. Failure to do so infracts judicial propriety and discipline. Consistency in judicial outcome is the hallmark of a responsible judiciary. Inconsistent decision coming out from the different bench shake public trust and reduce litigation to a punter's game. It gives rise to a various insidious sharp practice like forum shopping, which I was using the expression. Is practiced like a forum shopping, spoiling the clear stream of justice.
Yes.
Impugned order suffers from the vice of judicial caprice and arbitrariness and is liable to be set aside on that score. Judgment is appealed against before your lordship. Therefore, these are the ground. Next judgment, my lord. 2007-10 SCC 201. This is below.
Paragraph.
My lord, to be very short, I am telling you, because it's a big paragraph. What has happened in this matter? For a question, Bombay High Court set aside it. Bombay High Court formed one opinion and rejected the case. But Kerala High Court, just a counter view taken of the Bombay High Court. Third, when another matter is moved before the Bombay High Court was following the judgment of the Kerala High Court, not the Bombay High Court. Correct? This is the position. This is paragraph 19. I'm making it very short, that's the reason. What the Supreme Court is saying, kindly see. Kindly come to me, Lord. Page 97, last lines, last three lines. Last page 97. Similarly, the clarification by MCI supporting the interpretation put forward by the students was also noticed. Though the letter dated 17 September 2022 as such was not referred, both the two contentions were considered merely because Kerala High Court had accepted the clarification of the MCI. The Bombay High Court could not have ignored a binding precedent of a coordinate bench. If it wanted to take a different view, judicial propriety required that the matter be referred to a larger bench. Be that as may be, we find it difficult to sustain the reasoning of the High Court in the judgment. Now, what is binding? Binding is own High Court judgment. Binding is not other High Court judgment. You have to follow your High Court judgment. Most interesting. Then we have next one. 2010-13 SCC, 336, Santlal Gupta and others versus Modern Cooperative Group Housing Society Limited and others, 104. Page, Melody is at 104. Page 336. Page 336. Paragraph Milord 16, 17, 18. 16. Be that as it, my lord, got it?
Yes.
Paragraph 16. Be that as it may, the higher court
Yes.
my lord, got it? Be that as it may, the High Court has referred to its division bench judgment in BB Chibbat so and so, wherein the same provisions had been considered, it had categorically held that deeming approval was not legally permitted. In view of the above, it was neither desirable but not permissible by the coordinate bench to disapprove the earlier judgment and take a contribute to it. More so, extension of the period so and so. A coordinate bench cannot comment upon the discretion exercised or judgment rendered by another coordinate bench or the same court. The rule of precedent is binding for the reason that there is a desire to secure uniformity and certainty in law. Thus, in judicial administration proceedings, which enumerates the rule of law from the foundation of the administration of justice under our system. Therefore, it has always been insisted that the decision of a coordinate bench must be followed. In so-and-so versus so-and-so, this court held that a bench must follow the decision of a coordinate bench and take the same view as has been taken earlier. The earlier decision of the coordinate bench is binding upon any later coordinate bench deciding the same or similar issue. If the later bench wants to so and so, in the instance the position before us is worse, as the later bench has taken a divergent view from an earlier coordinate bench. Paragraph 19. Yes. Particularly taking note of their earlier decision holding otherwise. Here note has no, although learned advocate has cited the judgment, he has not referred it. Says niceties. Law is not required to be followed. Even in niceties of law is there, whether the court is bound to follow that law or not. Niceties of the laws, niceties of these laws are laid down by the great judges of our Indian judicial system. Niceties of the laws may not be understood by a very mediocre judge, but the great judges have made these niceties of the law. And that is the law of the country. That is a binding under Article 141 of the Constitution of India. If you don't understand the niceties of the law, you don't deserve to remain as a judge. You have to follow the niceties of the law. Law prevails over everything. Good, bad, like, dislike, whatever it may be. Niceties of the law can be understood by a good counsel. Niceties of the laws can be formed by the good judges.
Mr. Bandyopadhyay, why don't you
No,
stick to your pleadings?
I am saying
person has delivered a judgment. Partho Chatterjee's matter was being argued when it was being said by the learned counsel, see how the learned judge is vindictive. I stopped the hearing. I said, I shall not hear you.
No, I am saying of the niceties of the law have to follow.
Mr. Bandyopadhyay, you explained to us on the ground
I am
of-
saying,
all these judgments according, we have not heard.
I am saying kindly, no, your lordship is misleading.
Mr. Bandyopadhyay, why should you?
I am saying niceties of the law have
That
to be
we
understood.
yes, yeah, all right.
That's right. That's why I am saying.
Once the niceties are not understood, you cannot blame the judge, no? You cannot say that the judge doesn't understand.
If the judge, yes.
No, that
niceties of law has to be understood, my lord. We are in the legal, no, my lord. After all, we are in the peripheries of this. You can't ignore a law because this is the niceties of law.
Yes, Mr.
Now, in the instant case, the position before us, it was as a later bench, has taken a divergent view from an earlier coordinate bench, particularly taking note of the earlier decision, holding other without explaining why he could not follow the said precedent even while extensively quoting this judicial property and discipline are not served by such conduct. Thus, in view of the above, it was not permissible No constant so and so, so and so, so and so, so and so. No, আর অতগুলো পড়ে না। 21, yes, 21 kind is very interesting. 21, this is the first time, my lord, possibly this is my failure in life, but I have really read it and learnt it very nice thing. It is a settled proposition of law that what cannot be done directly, Lordship has got it. We are aware that no, which cannot be done directly, it cannot be done indirectly. That we are aware. I was aware. Now here interesting word kind of see. It is settled proposition of law that what cannot be done directly is not permissible to be done obliquely. Obliquely, not indirectly. Which you cannot do directly, you cannot do, is not permissible to done obliquely, meaning thereby whatever is prohibited by law to be done cannot legally be effected by an indirect and circuitous contrivance of the principle of quando aliquid prohibited et omi per quod dinevo. An authority cannot be permitted to evade a law by shift of contrivance.
Yes.
This paragraph 21 is squarely applicable in this case.
Yes. Yes.
But there are other two judgments have been referred here. I am not reading, kindly take note of that. But on this category, I do not want to take your losses that time. There are judgments. But delay and latches. Next point. Creation of third-party rights. Sorry, Miller, kindly give me just 1 minute. Are telling me, good, I agree that what should be said to court. Page 13, is that Alpha Tune versus 1974 SCC, page 285. Constitutional bench judgment.
That is which serial, Mr. In your
Alpha Tune and others versus the Lieutenant Governor.
Yes, right.
Uh-huh. 1975 4 SCC.
Yes.
Kindly come to paragraph 11.
Paragraph
11. At page, running page 20.
Yes, 20.
Nor do we think that the petitioners in the writ petition should be allowed to raise this plea in view of their conduct in not challenging the validity of the notification even after the publication of the declaration and so on. Of the two writ petition, one is filed by the one of the, there was apparently no reason why the writ petitioner should have waited till 1972 to come up to this court for challenging the validity of the notification issued in 1959 on the ground that the particulars of the public purpose were not specified. A valid notification under section 4 is sine qua non for initiation of proceeding for acquisition to have sat on the fence and allowed the government to complete the acquisition proceeding on the basis that the notification under section 4 and the declaration under section 6 were valid, and then to attack the notification on the ground which are available to them at the time when the notification was published, will be putting a premium on dilatory tactics, the writ petition are liable to be dismissed. Therefore, my lord, again I am repeating, my lord, they were sitting on fence. Borrowing the expression made by Justice Joymallo Bagchi, forum shopper came to the court and got the order.
Yes.
Okay. Well, next case, which I have given in the list, it has been placed by Justice Dotto.
Yes.
Sorry, Justice. I'm sorry. Advocate General. I'm very sorry. He has no scope to be a judge. You know what has happened? Just 1 minute, I am taking. Kindly, my lord, 1, 2. This is your lordship's kindly see. This judgment I am.
Which one you
page 14. Under serial number 4.
Notes.
My note. Kindly take my note, my lord.
Yes.
My lord, treat it that I have pasted every judgment. Otherwise, it will take time. I am just cut short the time I am doing it. Commissioner of Devon so and so.
Mr. Bandyopadhyay, I think you should go to the issue of section 165.
I am coming.
Other issues, Madan Lal, participation, everything has been placed before us.
Everything has gone. One of the issue I am showing to you, very important. That is, somewhere CBI has been referred in the judgment. Correct? Please, CBI has been referred. What the CBI is there? What are the materials were there before the legislature? Nothing was there. No pleadings, nothing. No materials.
Yes.
No pleadings, nothing. Let's assume, Millard, there is a report. Let's assume for the time being. Let's assume for the time being, there is a report. Any report is there. What is that evidentiary value of that? Report we have not seen. We have not got any chance to deal with the report. CBI has been said. Let's assume, for argument's sake.
Yes.
My lord, how far it is valid? How far, whether it has any evidentiary value? A report itself. On which basis some perception has come into the mind of any judges?
Yes.
Kindly take me, Lord, 2022 12 SCC page 200. Your lordships will get it in my compilation at page 360.
344.
344. 344. Case is below Rajesh Yadav versus State of UP.
Yeah, this was placed.
My lord.
Yes.
Paragraph 363, your lordships come.
Para 27.
এটা বার করতো জাজমেন্টটা তালুকদার
Para 27.
27 আমাকে একটু কাজটা করতে দিন সেকশন 173 সাবসেকশন 2 paragraph 27 section 173 subsection 2 CRPC calls upon the investigating officer to file his final report before the court. It being a report is nothing but a piece of evidence. It forms a mere opinion of the investigating officer. My lord, got it?
Paragraph 17 you are placing.
Paragraph 27, my lord, at page 363.
363.
3.
Yes.
Section 173 to CRPC calls upon the investigating officer to file his final report before the court. It being a report is nothing but a piece of evidence. It forms a mere opinion of the investigating officer on the materials collected by him. He takes note of the offense and thereafter conducts an investigation to identify the offender, the truth of which can only be decided by the court. The aforesaid conclusion would lead to the position that the evidence of the investigation is not indispensable. The evidence is required for corroboration and contradiction of the other material witness, as he is the one who links and presents them before the court. Even assuming that the investigating officer has not deposed with so and so, has not convinced so and so, not entitled for acquittal so and so. Therefore, an opinion can be the basis of my termination of service, which has not been proved, which has not been relied upon by the petitioner in his pleadings. No report has been relied in the by the learned single judge. CBI, as if CBI is a god and nothing has to be required to be done. Even the report is not there. It has to be proved, my lord. Is there any single allegation against any of my clients that he has committed this criminal offense? Kindly take it, my lord. The proceeding is continuing for years. Any of my client has been called as a witness, investigated, arrested, nothing. Termination of because of any perception. In a court of law, it has to be proved.
Yes.
But second one also, kindly see. MC Mehta. Taj Corridor matter.
Mehta.
MC Mehta versus Union of India. This Taj Corridor scam. 2007 1 SCC. Page 110, paragraph 27. At page 372 of compilation. At 390. One paragraph I will just read below. You 165 corporate dark detail.
Yes.
That's not applicable. What is it? What is it? Can I read, Miller?
Yes.
Paragraph 27. See, in K. Virasamy versus Union of India, this court observed with paragraph 17 as follows. The charge sheet is nothing but a final report of a police officer under section 172 of the Criminal Procedure Code. Section 173, subsection 2 provides that on completion of the investigation, the police officer investigating into a cognizable offence shall submit a report. The report must be in the form prescribed by the so and so, the nature of the investigation, the names of the person so and so, A, B, C, D, E, F, G. Then, as observed by this court in Satyanarayan Musal so and so, that the statutory requirement of the report under section 173(2) would be complied if the various details and so and so are included. This report is an intimation to the magistrate that upon investigation into cognizable offence, the investigating officer has been able to procure sufficient evidence for the court to inquire into the offence and necessary information is being sent to. In fact, the report under section purports to be an opinion of the investigation, that is, as far as he is concerned, he has been able to procure sufficient material for the trial of this so and so. The report is complete if it is accompanied to all this so and so. Nothing more need to be said in the report of the officer. It is also not that all the details of the officers must be stated. Therefore, what is that? This is an opinion. Opinion is not a final thing. For that reason, my lord, my service have to be terminated. Even the charge sheets which have been filed, not a single one of my clients has been made an accused.
Yes.
My lord, your lordship was asking me for Assi Baba. Asking me, my lord, what about the 165 of the Indian Evidence Act? 165 of the Indian Evidence Act.
That has been extensively argued by Mr. Dotto.
But your lordship was asking.
Yes, that what is your?
My lord, I hope Mr. Dotto has not submitted that which I have submitted. If you invoke 165, I get the chance to cross-examine.
Yes. He has argued that.
He has argued. I have also argued. Then, my lord, whether Justice Subroto Taluka's judgment has been placed.
This September judgment which you showed us.
No.
The judgment against which you prefer the selfie.
Can you take this?
The first one.
Now, dealing with 165. Dealing with 165.
Show us.
আপনার জন্য
আর জজের জন্য?
জজের জন্য আছে সাইটেশনটা পড়ে দিন
This is, my lord, 2022 SSC online Calcutta 3991.
This is which one, Mr. Bandota?
Ramesh, West Bengal Board of Primary Education others versus Ramesh Malik. This has been placed. I don't think. Just for 165.
No, we haven't.
I am just referring the judgment only for 160. It's a big judgment, but I am relying only for the 165.
Paragraph 10.
This is in a different matter, no? Ramesh Malik. Para 165.
No, para what?
6110.
Para 61.
Achha.
Subparagraph 10
and 11.
And 11. At page.
Page number
Page is page 48. It's very small. It has been written at the top. Can I just make out for you? Let's find out. At the top, it's very little. Here,
yes.
Page 48.
Yes.
Flag the
61.
Can you take my copy? I have flagged
61 subclause 10 you said.
Subclause 10, huh?
Page 40. Yes, got it.
Similar. In connection with the above discussion, this court must now notice that the line of argument which has emerged from the learned counsel for the appellants.
Just.
Malur, got it?
Just.
Page 48. Malur,
Page 48.
40, yeah?
48.
48.
46.
46. Huh?
46.
Very small. Very small.
Yes. 10. In connection with
the above discussion, this court must now notice that the line of argument which has emerged from the learned counsel for the appellants on the procedure of taking evidence by the Honorable Single Bench applying section 165 of the Evidence Act. As discussed earlier in this judgment, learned counsel for the appellants have strenuously urged that evidence in the manner required to be taken under section 165 of the Evidence Act by a court has been not so done. The power of the court to take evidence under section 165 have been discussed in reference Ramchandra State of Haryana so and so 813. What is the true role of the judge trying a criminal case? He has to assume the true role of a referee in a football match or an umpire in a cricket match. Occasionally answering the follow and Maitland point out the question how is that or easy to, in the words of Lord Canning, drop the mental of the judge and assume the role of an advocate. Is it to be expected?
This was placed, I think. Anyway, you place.
Well, if it is placed, then I don't need to place.
81.3 SCC.
No, 81.3 SCC may be placed by
you are placing that extract of
81. Yes, extract.
Yes, anyway, you.
Anyway, this is. I will not disturb your 81. Since it is now, kindly come to paragraph 11. Next paragraph. In the teeth of the above stated elucidation of the law, which albeit follows from the manner of conducting a criminal trial and may not be wholly apropos to writ proceedings, which are not controlled but guided by statutory procedure. At the same time, this court finds a summary application of section 165 by the Honorable Single Judge to be offensive of statutory procedure and constitutional safeguards, while recognizing the jurisdiction of the Honorable Single Judge to choose the manner of exercise of its prerogative jurisdiction. It requires no emphasis that justice must not only be done, but also seen to be done. Next, on the issue of restrictions. Therefore, a coordinate bench also has taken this view, 165. And 165, other arguments I have made. And this is not known. I have, in my entire career, I have done the evidence in the proceeding, Vikiri Paswan's case. And in the Vikiri Paswan's case, in the read proceeding, this Vikiri Paswan, that time public interest litigation was not there. And it was in 1992, 1993. What has been done? In Vikiri Paswan case, the judges have not called the witness. Come here. Put the questions. The then Advocate General was against me. First witness was led by the then Advocate General Norman Gupta, which I have cross-examined by. The other witnesses have documentary evidences were placed. Parties have got the exhaustive opportunity to examine and cross-examine. It is not that the writ court cannot take an evidence. I am not saying so. In an extreme cases of liberty. It was habeas corpus matter. I tell you, Lord, if I remember the day in 1993, my leader was Mr. Bhonath Sen.
Yes.
When the case diary was produced, the entire file was given. And it was a bench presided over by Justice Washington Sen in courtroom number 19.
Yes.
The entire case diary was given to us. Mr. Sen, my leader, was cross-examining the witnesses. I was thorough. Very quickly was going to the records, and one record I have shown to my senior. Senior has placed that to the senior judge, the judges. Judges have stopped the evidence. Direct CBI. The document itself says that yes, the matter needs a deeper investigation. And it is a case of a murder written by the DI. I have seen that without evidence, examination of evidence.
Yes.
There are so many lawyers are there. They have also seen the evidences in their respective cases, but not in this way. The judge will call. Yes, tell me what is this questions and answers. Just give me the questions and answers. The judge has been made.
Yes.
Judge is making questions one after another.
We have seen that.
Therefore, whether the judge had the role of the prosecutor or the judge.
Yes, yes, that we have seen, that has been argued also before us.
Anyway, just I am reminding to us.
Yes, yes.
There was a judge. A judge cannot be prosecutor of his own case. He should judge.
Actually, aptitude test হয়েছে তারপরেও
Anyway, I'm not going. This is the way evidence are given to you. No, all questions have been raised by the judge. Was it a proper procedure followed under section 165 of the Evidence Act?
Proper procedure meaning what was the procedure?
165 procedure, see the procedure.
That is up to the discretion of the judge concerned.
Discretion. Evidence may be called. Evidence may is a discretion, but judge will not be a prosecutor.
No, that is separate. Judge will not be
but
the prosecutor.
Discretion, if you exercise the discretion, you have to give reasons.
Yes, yes.
But there
is put by the judge, na, you are there. Oh, if anybody of you may be.
Mr. Tiwari was there.
Where is Mr. Tiwari?
Questions of
Anyway,
judge.
it was put by the
No, the questions I've seen, the questions have been
Yes,
put
yes.
by the all the questions. And thereafter, board has been asked to cross-examine, board did not cross-examine.
Who did not cross-examine?
Board. As per
Yes,
records.
Yes, board said we were not given the opportunity also.
What?
That was we were not given the opportunity.
That's all right. Very good, board, if this case. Then today, what would be done? If this evidence, your lordships, if he upholds the judgment, reject our case, then on the basis of the reasoning, and one of the reason of the evidence, let's go and see the judgment now. Examine. Now judgment. And last I will few case that the law will prevail over the equity. I will show that and I will finish. Kindly come to the judgment. I don't know what from your lordships have read. Can you take my copy, pillar, page 551?
বোর্ডের পেপার বুক থেকে পড়েছেন আমি মার্ক করেছি পেজ নাম্বার
Oh, 73.
Oh.
Yes, yes.
Now judgment, 610.
ইন্টারনাল পেজ রেকর্ড করলে
Internal page 2, internal page 1, 2. Kindly come to internal page 3.
জাজমেন্টে
Judgment. My lord, got it? Judgment?
Yeah, just. Yes.
Kindly come to paragraph 5. First, see paragraph 4. When the petition filed the petitioner, they wanted the authorities to file a report disclosing names, numbers, rank, category, etc. of the non-trained candidates who have been recruited by the board from TET 2014, including the date of recruitment, and to treat the petitioner equally with the non-trained candidate. This was the scope of the petition. Now, similar paragraph 5. During the course of hearing, the petitioner disclosed various particulars collected from publication made by the board in the website showing that there were serious illegalities. Where this? Where it has been disclosed? Such a vague lines will decide my career. Made by the board in the website showing that there are serious illegalities in preparation so and so process when viewed in respect of the untrained candidate at the time of recruitment and while disclosing such particulars, They made it clear that all their allegations of illegality in recruitment are in respect of untrained candidates at the time of recruitment who are given appointments to a recruitment program. At the same time, they made clear they do not have any grievance in respect of the trained candidates who are transferred and given appointment in the recruitment. Therefore, the candidates who are trained at the time of recruitment outside the scope of the petitioner paid for filing supplementary affidavit which was granted, and from the supplement to the it became evident that all the petitioners are qualified to and participated in the 2016 recruitment process, and they are called in the video but did not get the job. The court directed the board to file one report as to so and so. Then paragraph 7. From this said backdrop, the party petitioners found and alleged that the particulars given there are absolutely false, and because the lowest number of impaneled candidates was shown in the report as 14.191, whereas throughout the West Bengal, 82 candidates below 13 were appointed, and the petitioners prepared a tabular sheet. But before the learned single judge, no affidavit was filed to this extent. Kindly mark this one, this paragraph. Whole West Bengal, has written. The learned single judge has taken note of the whole West Bengal, but it was district-wise selection. It was a district-wise selection. Suppose in one district, the lowest one has got 13. Suppose in Kuchbihar district 13, district-wise selection he has selected, and in Purulia district he is 15. He may not get it. And you have taken Purulia district is compared with Kuchbihar district is compared with the Hobson's choice.
Yes.
Justice is not a one-way traffic. Justice is a double-way traffic.
Yes, come to the next. Which paragraph you want?
That's the coming. Why I'm reading one after. Therefore, this is wrong. When I was pressing to your lordship every time, I was from district-wise. I marked it to your lordship. Now, district-wise selection. He has gone to the West Bengal-wise selection. How it can be? Suffers from illegalities. Then come. Who below are appointed by this one, so such exception filed in the form. Now, my lord, kindly your lordships will find, my lord, Rule 8, Sub-Rule 5 of the West Bengal Primary School Teacher Recruitment Rules 2000, page 108, Volume 1 of my paper book, that speaks about district-wise selection. That speaks about district-wise selection.
What is that?
My lord,
what you are saying? This
is, my lord, Rule 8, Sub-Rule 5 of West Bengal. Kindly lordships take, my lord, page 108 of Volume 1 of my paper book.
You read it, Mr.
I'm reading. No?
108.
My lord, 113? 85.
That has been
council wise, district primary school council wise. DPS, protected district.
Yes, 113.
Then let's see, page 113, lordships kindly come. Rule 8, Sub-Rule 5. 8, Sub-Rule 5. 113.
Yes.
This selection committee shall prepare separate council-wise panel. Council-wise panel? My district primary school council.
Yes.
How can you compare Purulia district with the Kuchbihar district, Jalpaiguri district with the Bankura district? Next page. Paragraph 8, kindly see. From the pleadings of the pleading, found they wanted marks of last time panel candidate different categories like SC, ST, but no such particulars supplied and produced by the board despite direction given. In the affidavit of the board maintained silence in this regard. How they wanted marks of last time panel candidate? Is the information center, the High Court will be turning into. then made the application and the Right to Information Act. And court will direct that you give the information, the Right to Information Act has to be annulled. Then Miller paragraph 9. In respect of holding aptitude tests, the chairman of the board in his report said the aptitude tests were taken, but from the evidence adduced by the interviewers and the candidate is proved before that no aptitude test was taken. Give me chance to cross-examine. Send it back to the learned single judge. He has given 556 names are there. Unknown procedure of law has been followed.
Yes.
Page 56, 557. Then kindly come to page 559.
Paragraph
10. Why marks is illegal? Because interview evidences were there. Kindly come to paragraph 10. Therefore, the marks given to the candidate against aptitude test is wholly illegal and false exercise to who do it of concern, including the court. Because of paragraph 9, paragraph 10, because of invocation of 165 by the single judge without affording any opportunity. Then because of paragraph 9, the 10 finding is there. If 9 goes, how 10 remains? Either your lordship has to say whatever the correct procedure has been followed by the single judge. No requirement of the cross-examination by any party. Whatever the judge will ask, judge will take the role of the prosecutor and things. Otherwise, judgment is required to be set aside. Then come paragraph 11. The board has not given any reply in respect of awarding 9.10 and 10 marks to a large number of candidates. Can this question be raised by the court? I hope, Milord, lordships can remember, Milord, I have argued this point in 2 or 3 occasions that Sadananda Doloi's case. Before your lordships, Milord. Right from that, shall I cite the judgment? I don't think it is required. Can you go in a microscopic evaluation? Can you be a fact-finding authority for a selection process? Therefore, these findings in paragraph 11 is contrary to the law laid down in the Sadananda Hallow's case. Read with my lord 2 judgments of a minor justice Chakraborty. I will give that one later. One in the civil, and also in the recent that senior primary teachers.
Mr. Bandyopadhyay, please come paragraph 16.
16. Okay. Yes. Few of the cases have been there. They have been marked 9.5, 10, 10.
No, 16. Internal base,
Oh, sorry,
paragraph
16. I'm sorry. 16. Though the relevant rule 7 of recruitment rules of 2000 mandates constitution of selection committee, no selection committee was constituted for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment teacher. It was done by one outside agency. It was not done.
Please.
A third party which is not at a part of the board, and this party was named as confidence secretary of the board. This is clear violation of the recruitment.
What is your answer?
Well, this is. I hope Mr. Advocate General has given the answer to this. Well, this answer will be given by the board. This answer will be given by the board.
Take it from
Because I can't say, my lord, it is. See, my lord, kindly see from my angle.
Yes, we have seen it.
Only no.
You are not parties. You are
No.
Yes, we have.
You have seen me on the, one after another, my lord, in a facet. See another facet of. Right? See, and it is and always love. I always love that smiling of your love from this side or that side.
Yes.
Now, my lord, see. Am I responsible?
You were there in paragraph 15, Mr. Bandyopadhyay.
Paragraph
15. You are placing paragraph 1.5.
Yes. No, I'm looking to the entire thing. very, what the wrong I have committed. Let's assume, my lord, this has been done. Let's assume. Am I responsible? Whom I will be called in an interview. I have gone there. And after 10 years, my service will be terminated. Am I responsible? Kindly look also from our angle also. Some CBI, something has been given. Does not know that. Is there any finding? Any of us has been arrested? What is saying? An unfortunate country of us, that if some persons have committed any offense, you have arrested and you have not finished the trial. Now, my lord, I was reading that paragraph 15. Just I will very 15. The board has not given any. So far the 14 is concerned. My answer is, that's further on those cases, etc. And how many cases have been given example? Hardly, 25 or 30.
1,20,000.
Huh?
For setting aside 36,000.
Huh?
Yes.
A total candidate was 1,22,000 at that point of time. Out of 1,22,000, you have found out a few cases. In Bengal, it says, na, ukun bachar moto kore bachbo. And without any affidavit, without anything. That's further on this case, Lord, kindly remember, I am not pressing it. My Lord Justice Chakraborty, I am not pressing this. Pressing means relying, not reading. All the judgments which have been referred in my notes, all that judgments are being relied.
Yes, yes, yes. We understand.
Paragraph 17. Then from the gross illegality in the selection procedure in the recruitment exercise 2006 conducted by the board, it is clear that the board in its official, including its former president, who is now in custody after arrest by department for the transaction of used money in the recruitment process conducted by the whole affair like affair of a local club. What is this language? Your lordships will say something to me. Is it a language of a judge of the court, high court?
Oh.
Your lordships will scold me. But you see what is the language? Local club, and now it is gradually coming to light over enforcement director and jobs for primary school teachers were actually sold to some candidates who had got the money to purchase. Where is this findings? Finding of fact. You are saying this without any evidence, without anything. A court will say. I can understand it is not a discussion in the TV channel after 7 o'clock.
Yes.
What is the evidence? What is the findings in the judgment? Where you have shown? Not based on any evidence. A corruption of the magnitude was never known in the state of West Bengal. He is not a philosopher or a politician. The former education minister, the former president of the board, and a number of middlemen through whom the jobs were sold like a commodity are now behind the bars of the CBI. Is it a relevant finding? Is it a relevant finding? But if this is the ground for termination of my service, this ground should be, this allegation should be proved. Rather, I put it in another way, they should have proved if these persons have taken money from me. And I have been arrested. Nothing is there. Everything is in air. Nothing is here. Everything is on air.
Yes.
My Lord Justice Mitra, it's all right.
Yes.
Now, paragraph 18.
That you have said. That you have.
Niceties. More I will not say.
Now you can conclude.
My Lord, almost my Lord, on 43 years, now I'm 44 years practice. I have always tried to find out the niceties of the law and I love the law in that way. And I say this profession, this is my passion, it is my preference in life. All the time I love after the niceties of law. And here in a case, the learned single judge is saying no niceties of law.
have been cancelled.
Yes.
Yes.
Now I will take the judgment as normally we do in appellate bench and show that there is no ground of in support of a judgment. Judgment cannot stand on merits. Whatever be, I will take that as a neutral argument which you make. These are the reasons we cannot accept it. Not sustain it.
And who are the persons appearing for the applications which have been filed in connection? Any counsel present for the thousands of applications filed?
Those applications for
Applications filed.
My
lord,
addition of party because of that, my lord. Before the single bench, my lord, there are lot of writ petition pending due to publication of 2022, my lord, the 20 in connection of 2016, my lord, selection process. There are huge illegalities, my lord, because let's make
You are appearing for. We will listen to when you will get your chance. You argue before us.
my lords, all the
Wait, Mr. Said this way we cannot proceed. Please wait. Yes.
Some of my application is already. Some of my application is already.
What we are delivering the judgment. Don't be so silly, Mr. Lady. For years of practice has gone by. We are delivering the judgment. Then why you are interrupting? Does it seem if we call upon him for a question?
responsibility, my lord, I am submitting before your lordship. All the SLP were filed by the, my lord, in-service teacher, those who were, my lord, lost the job. My lord, they filed the SLP. My lord, one after another SLP were filed. But initially, when the main SLP was hard, my lord, your lordship just, my lord, Mr. Bandopadhyay, senior advocate, my lord, placed the, my lord, SLP. My lord, that SLP was disposed of fast. Then, my lord, all the SLPs was disposed of in terms of the that order.
Those SLPs were also leave to appeal.
Yes, yes, yes.
So you give us those, and who are the applicants? We are not
All
being able to
32,000. All 32,000.
Now there are 44 appeals. Sir, if you don't assist us, how can we assimilate the record?
Well, may I have?
There are 44 appeals, and there are about 80 till date. I think there are 86 applications.
Yes.
We have taken the pains of going through each of the 79 applications, and we have made a note. But we don't find who is the councillor.
Well, lordship may not require to read the applications at this. This is my proposition. Lordship may consider. Lordship is now in the midst of hearing. Now there may be thousands of applications who may be here, may not be there. But there are large number of candidates based on this judgment and directions of the Supreme Court. They are there. If anybody, despite filing applications, despite hearing continuously, choose not to come.
No, not to come now. There are some advocates who are appearing. So, because he took a point that though my application was allowed,
yes,
department has not brought my name in the list. Kindly consider, one is an addition, other is to give an intervention to you. That all right, I will hear you, your advocate's name will be there. But if it is an addition, the 79 applications, more than say 2,000 incumbents were there. If we allow, the department has to bring them on the cost title of the matter.
That would take a lot of time. That would take a lot of time.
You suggest.
So my
then you
suggestion would be lordships need not enter into the applications at this stage at all.
At the last stage also,
Yes.
what we will say about the application.
Madam, once the hearing is concluded, fix a particular date. On that date, lordship may ask the respective councils appearing for the applicants, and lordship decide
Then
it.
again 1 month here.
No, there would
Now
not be.
again,
Yes, yes, yes.
things will come. Again, people will
Yes,
be here. This way we cannot finish up. So subject to what you say, we are suggesting if you can get the who are they, these there are 70 appeals.
Yes.
70 applications approximately.
Yes.
Now, if he can give you the SLPs, which are the how many persons comes within that?
Well, that would consume lots of time of your lordship.
Last of
Because
At one junk, or we can allow all the applications.
Yes.
We can allow all the applications, and we can hear your objections to it. No problem there.
Then it takes a branch.
No, it will not take a branch.
Yes.
That is what we are interacting with you. Suppose there are 70 applications. Leave us out 10 applications. Some are for, say, Order 41, Rule 27. As we Tuesday, I think.
Tuesday.
Make an endeavor, if you can give, you can.
As soon as by this week I am trying, if not by Monday, definitely, I will hand over your lordship. I will indicate whether the application was allowed or not.
Subject to cancellation. If we have done not doing subject to cancellation, then it will happen when the scope, the vacancy, that will be also increased. But the vacancy is a big spot.
Let us.